Good morning and welcome to our visitors. We are going to get started this morning. We have a pretty robust schedule, so we'll ask the RBC members to take a seat, please. So good morning. Thank you for joining us for today's meeting of the D&C Rules and Bylaws Committee. My name is Mignon Moore. I'm from the District of Columbia, and along with my co-chair Jim Roosevelt from the Commonwealth of Massachusetts, we serve as co-chairs of the D&C Rules and Bylaws Committee. As we begin, please join me in reciting the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. So before we get started with our Rules and Bylaws meeting, we're going to hear from our chairman, my good friend, Chairman Harris. Would you like to bring us some words of wisdom this morning?
Well, thank you so much, Madam Chair, and thank you, Mr. Chair, Jim Roosevelt. Thank you, members of the Rules and Bylaws Committee, and thank you all, the guests of the Democratic National Committee and this RBC meeting. I first and foremost want to just thank the RBC. This committee has worked tirelessly since I became chair to examine our rules, to examine our presidential process, to help ameliorate and work with our state parties on a number of issues. And they've just done a wonderful job. And they've done it in an amazing fashion, in the way that we have historically seen this really powerful and important committee, conduct itself. And part of that is because of the fabulous leadership that we have for this committee. I cannot say enough about how grateful I am for the stewardship of Mignon Moore and Jim Roosevelt. And I just want to say on behalf of the DNC and the Democratic Party, Jim and Mignon, thank you again for all the things that you do. There are things that you are doing even when folks don't know you're doing it. But thank you for all the hard work and the efforts that you put into this. And this is my challenge to all of you. You know, I often quote Dr. King's letter from a Birmingham jail. But I talk about this one quote where I say, or where he said, that we will repent in this generation not merely for the hateful words and actions of the bad people, but for the appalling silence of the good people. But right before Dr. King said that, he also had this really poignant point about the issue of time. And that's the one thing I've been telling a lot of folks. You know, we have a lot of assets. There are a lot of things that we have, but something that is finite, that we don't get back, is time. And Dr. King said that time itself is neutral. It can be used either destructively or constructively. And more, I feel that the people of ill will have used time much more effectively than the people of goodwill. My friends, there's only a short amount of time between now and the November 2024 election. And even before then, we have an election in 2023. We know that in this room are the people of goodwill. People who are fighting each and every day to make sure that the American dream is available to all of America's people, regardless of what we look like, regardless of who we pray to, regardless of who we love. The question is, will we use our time effectively to make sure that we can constantly stand up for America's people? I'm proud of our president and our vice president because I know that they do. This is not about power for them, but it's about progress. We have seen the chaos on the other side. So all I ask of each and every one of you, as we do our work here in this committee, but as we do our work as Democrats across the country, that we use our time effectively to promote and do the work of this party, which means standing up for democracy, standing up for our freedoms. So, Madam Chair, Mr. Chair, thank you so much for having me. Members, thank you for all the hard work and efforts that you put into this work for our party. And thank you all for standing up and being proud of being a Democrat. Thank you all. Take care now.
Thank you, Mr. Chair, for your very kind words. We really appreciate it.
Jim?
So, I'm now going to ask our parliamentarian, Helen McFadden, to call the roll.
Thank you.
Thank you, Mr. Chairman. Mr. Applebaum. Here. Ms. Blanco. Ms. Brazil. Aquí. Mr. Brennan. Mr. Brennan. Okay. Mr. Burgos.
Presente.
Ms. Cardona has given her proxy to Ms. Blanco. Mr. Curry has given his proxy to Mr. Elete. Ms. Daughtry has given her proxy to Ms. Brazil. Ms. Desai-Martin. Ms. Martin. Ms. Dowdell.
Present.
Mr. Elete. Here. Ms. Fowler. Here. Mr. Uridia.
Aquí.
Mr. Jones has given his proxy to Ms. Martin. Ms. Kmark. Here. Mr. Leone. Here. Ms. Lewis. Here. Ms. McGarrick has given her proxy to Mr. Ray. Mr. Martin. Here. Ms. Martinez. Mr. McDonald.
Here.
Mr. McGlinchey has given his proxy to Mr. Spate. Mr. Mitchell has given his proxy to Mr. Iridia. Mr. Ray. Here. Mr. Saunders has given his proxy to Mr. Applebaum. Mr. Spate. Here. Ms. Schwecker has given her proxy to Mr. Leone. Mr. Thompson. Ms. Weingarten has given her proxy to Ms. Moore. Ms. Williams has given her proxy to Ms. Martinez. Mr. Chairman, you have a quorum. You have all but one here.
So, per our charter and bylaws, a quorum is constituted by 40% or 14 RBC members, present in person or by proxy, and we certainly do have a quorum. I'd also like to briefly acknowledge Carol Ronan, who the chair has appointed to join our committee. Carol hails from Illinois and has been a great DNC member. While she was not able to join us today, we look forward to ratifying her appointment on Saturday, tomorrow, and look forward to welcoming her at our next meeting. I want to recognize the teams who work tirelessly behind the scenes to make sure our meetings run well. In addition to thanking Helen for her continued support of this committee, Mignon and I want to acknowledge Veronica Martinez-Roman and the Party Affairs team, Aaron Buckley, Jenna Whitaker, John Mott, and Rick Boylan, who continue to work tirelessly to facilitate our delegate selection process. We would also like to express our gratitude to the DNC leadership, Sam Cornell, Mary Beth Cahill, and Nick Bauer, the Secretary's Office, and DNC Legal Counsel, Andy Levine. Thank you to everyone who contributes to making our meetings run smoothly. The first item of business before the committee is consideration of the challenges from Alabama. You all previously received an email with a link to a folder containing the materials pertaining to this challenge. The written report of Hearing Officer Kim Keenan is also included in that folder. We will hear from the hearing officer in a moment, but first we wanted to review the process to date. In June, the Office of Party Affairs received complaints from 3 sets of challengers that alleged irregularities in the conduct of Alabama State Democratic Executive Committee meetings, including a meeting on May 6, as which a new set of party bylaws were adopted, which the complainants argued are in conflict with the DNC's charter and bylaws. The DNC Executive Committee voted in June to refer all pending and future challenges related to the Alabama SDEC's May 6 meeting that the DNC received to this committee. Since that meeting, we shared the rules of procedure with the 3 sets of challengers and the state party. We appointed Ms. Kim Keenan as the hearing officer to hold an evidentiary hearing in accordance with our rules of procedure. Ms. Keenan is a Democrat who is an experienced litigator, mediator, and arbitrator, and a neutral in the context of this challenge. She's a recognized leader among multicultural social justice organizations and has served as general counsel of the NAACP and president of the National Bar Association. That hearing took place on September 8 here in Washington, D.C. All members were given the opportunity to review the hearing, and the transcript is included in the online materials. The issues raised in the challenges are complex, as demonstrated by the 9 hours dedicated to the hearing and the hundreds of pages of exhibits submitted by the parties. Our rules of procedure provide for the hearing officer to file a written report to the committee. The report includes findings of fact, conclusions of law, and a recommendation for disposition of the challenge. Ms. Keenan's report was provided to all parties to the challenge and to committee members. Ms. Keenan's recommendations are not binding, but will inform our discussion. In a moment, I will ask Ms. Keenan to present a summary of her report to this committee. Following that presentation, we will hear from the challengers and the challenged party for 20 minutes each. After the conclusion of their presentations, we will have 20 minutes for questions. During this time, members may direct questions to Ms. Keenan or either party's representatives. We will then move to our discussion of possible solutions. Mignon?
With that, I will now ask Ms. Keenan to present her report on the challenges. Please hold your questions until after we hear.
Good morning. Do I have a mic? Good morning. I'm here today to present a summary of my report as it was described to everyone. I am from Washington, D.C., and I heard the testimony from both sides. We had a 9-hour hearing, and I have reviewed not only the 2023 challenges, but the sort of predecessor 2019 challenges. So it is a voluminous and substantial record. So I hope to condense it in a way that makes sense for everyone here today. So the history essentially is that Ralph Young filed a challenge in 2018 saying that the representation of the Alabama party was not basically consistent with the goals of the DNC. That challenge resulted in another hearing examiner coming and obviously presenting to this body or some other body that that the party's goals were not being met and that changes needed to be made. And as a result, there was a 2019 bylaw change that basically led to sort of a broadening of diverse representation in the Alabama Democratic Party. Fast forward to May of 2023, many of those changes were reversed. And that reversal prompted the challenges not only from Mr. Young, but Ms. Tabitha Eisner and the additional, I think it's like 40 Yeah, it's 55 total, including her challengers, and then, of course, Ms. April Hodges. So we're here today, essentially, if you look at it, as you said, from a legal/rules/neutral perspective, essentially, there are two challenges that go to the heart of this matter. And the first one is that there was a charge of a qualifying fee. And that fee was first sort of surfaced by the previous chair of the SDCEC. So that person was not there at the time that the changes were made in May. And that pronouncement that if you were elected to the SDEC, you then had to pay a qualifying fee. And the two things together are what make you eligible to serve. But the notice around the fee is very ephemeral. Everybody understood there was a fee. Historically, there was a fee. I don't believe there was a nefarious source to the fee. I believe that people paid, and people on both sides had paid the fee. But unfortunately, the fee didn't have any rule support or any objective support. So in effect, it was alleged to be a poll tax, and it does follow what happens when you have a poll tax. You cannot participate unless you pay the fee. But the problem was, while there was a window to pay the fee, the notice of the fee actually said that you could pay the fee after you were elected. But there's no time period specified. There's no, curative portion or time. And so what happened was people participated. They participated in 2019. They participated in 2023. And then, boom, they get to May. And then there's concern that the fee isn't paid. And so that was the reason I found that while the fee did not have a sort of a nefarious intent, the actual import of the fee is that it denied participation, and that was not consistent, certainly with, a broad reading of the DNC's rules, but there was no specific rule that was supported even locally. So that was, I felt, a fatal flaw in terms of the May changes in the bylaws. Preventing that number of people from participating was probably the difference between those May bylaws passing. And then the second key point that's outcome determinative is this notion of whether groups, Asian, American, Pacific Islanders, youth, this LGBTQ, all the different groups, so I'll just say them all together, that these groups were, on point 2, that these groups, let me just go to the note, that these groups would now be a part of a committee and not a part of a caucus. And the notion was somehow that as of the May rules, making them a committee wasn't really that much different, right? That it was a distinction without a difference, but that is not, in fact, the case. Caucuses have a lot of self-determination ability. They are able to do things. They are able to choose their members. They're able to move forward in a way where they have determination over who their members are and who's appointed and who's added. But once you become a committee, that right is delegated off to the executive committee, which is a different committee whatsoever. So a lot of how this comes to be, this notion of committee versus caucus, is deeply steeped in the history of the Alabama Democratic Party. And I like to say that what happened here is a perfect storm of the faraway past and the near past basically colliding with the present. And in the present, we have decided that there would be broad diversity, that the tent requires that there be broad diversity, and the rules that were promulgated in May of 2023 basically reverse that progress. The whole purpose of the 2019 rule changes was to increase diversity in an affirmative way, and now in 2023, all those gains were literally being stripped away because now that there's going to be a committee and not a caucus, it makes a difference. Now, the party's position is that, again, there's this unique history where black Alabama Democrats really had to sue, protest, and be activistic to get the equity that they deserved in the party. And so because of the lawsuit that created that, unless you can meet the standard that they met, you can't be a caucus. And I think that's mixing an apple with an orange. The lawsuit is a thing of its own design, created by disparities that existed at a certain period in time. But to create that 15% barrier as a barrier to other groups that by definition couldn't, it would be impossible for Native Americans to reach 15%. So basically you're saying they will never have a caucus. They will never have self-determination. And that's true for basically all of the other groups, not all, when you think about youth and people with disabilities. But basically for the other groups, Hispanic, AAPI, it would be huge. LGBTQ, at this time, it would be virtually impossible for them to make 15%. And I took the testimony of everyone who came. We made sure noted the 9 hours. But the 9 hours was so that everyone who wanted to participate could, whether they participated by Zoom or whether they participated in person. And they were very powerful in their testimony regarding the fact that they were not able to participate. And I think, while, again, both sides there's two sides to every story in this, and I tried to make sure that I put both sides in the report so that it wasn't sort of lopsided. I mean, there really is a side on both sides, but I think at the end of the day, if we are to look at what the goal should be in this process and what the goal of a party is in the first place, the rules should bend toward inclusion and making sure that people have the opportunity to participate without sort of rules that were intended for one purpose, but they're being used for another purpose. So I don't find that a fee in and of itself is not appropriate. I find that a fee under circumstances where it cannot be applied and cannot be cured in a way that allows participation is a fee that really does, in fact, become a poll tax. So I think that's the high points of my report, and I did, in fact, conclude that the May 2023 bylaws needed to be, could not stand under these circumstances, and that, in fact, that it would be the 2019 bylaws that would stand until something new was done in the interim. And I think that pretty much, there are other claims about different things. There's 15 of them, but if you think in terms of what is outcome determinative and what would be key, those are the key points. Anybody have any questions?
Thank you, Ms. Keenan. We appreciate your thorough consideration and recommendations regarding the complex issues involved in these challenges. So I'll turn this back over to Jim before I take questions.
So we will next hear from the challengers.
Yes.
Appearing on behalf of the challengers today are Tabitha Isner and Ralph Young. As a reminder, each side is entitled to 20 minutes of oral argument in front of the committee. The challengers may divide that time between their representatives, but they are collectively limited to 20 minutes.
Okay.
For members, there will be time for questions following the presentations from both sides, so please hold your questions until both presentations are complete. The challengers are now recognized to present their arguments. I will give you a warning when you have 3 minutes remaining, and again when you have 1 minute remaining. You may proceed.
Good morning. My name is Tabitha Eisner. I'm the Vice Chair of the Alabama Democratic Party, and I'm here representing myself and 54 other challengers who joined in this effort. I want to thank you for hearing our challenge and for providing a process. I want to thank Ms. Keenan, who did an excellent job of trying to keep us on track in those 9.5 hours. So thank you all for being here. I want to start by telling what we see to be the overarching story that's happening right now, and what is at stake here. The 2019 bylaws were specifically designed to ensure representation of non-Black minorities, not at the expense of the Black members, but also without allowing Black to be the only minority group that had special protections. Chairman Kelly and Dr. Reed were so committed to rejecting those 2019 DNC-approved bylaws that they were willing to repeatedly break established protocols and escalate their mistreatment of the non-Black Diversity Caucus members to reach that goal. First, they tried to get these members to stop participating in the committee by not communicating with them. When that didn't work, they tried making it difficult for those members to get their credentials. When that didn't work, they denied those members credentials altogether. It is important to note that without the discriminatory methods that occurred on May 6, those bylaws would not have passed. They knew that they had to discriminate and exclude in order to pass the bylaws they wanted, and they were willing to do so. They have demonstrated an ongoing disregard and defiance toward all rules which limit their power, especially rules that you have imposed upon them. I want to share with you a few stories from the last year. There are 1,000 stories we could tell, but just to focus in on a couple. One is that in preparation for the meeting on May 6th, the group of state committee members in Alabama made a plan for ensuring the full participation of members with disabilities. It's never been done before. We've never had real accommodations for people with disabilities in Alabama. But we got together, we formed a committee, we made the efforts, and we put together a plan. The plan included video cameras at each microphone and screens so that images of those people speaking would be projected onto the screen, with closed captioning for those who are hearing impaired, for those who are having a hard time seeing in the back. The setup cost $900, and the party was unwilling to pay for it, so committee members stepped up to pay that fee. Nonetheless, on that day, all of those materials were unplugged. The screen was blank, and the day proceeded with no accommodations. Not because it was costing the party anything, not because there was any reason not to provide such an accommodation, but simply because they didn't want to give us that win. Second example, the membership list for the state committee in Alabama has been remarkably hard to get a hold of. I have assembled a list on my own. I can tell you when vacancies became available and when they were filled, and I did that by watching hours and hours and hours of video of meetings, following up with people to find out what their proper spelling of their name was, what their email address was, etc. Keeping track of a membership list is harder than you might think, but it's not impossible. That's why it's so baffling that the chairman and his administration have been unable or unwilling to produce a list of committee members. Every time they are asked about it, they say, absolutely. You don't have that already? Isn't that on our website? And they promise you'll have it by the end of the day. But a year has gone by, and no such list has been produced. When Ms. Keenan asked for that list, the same thing happened. They promised it within a day, and they did not deliver it until well after the hearing. The list does exist. We've had meetings. We've had a vote by mail. There must be a membership list, and yet they refuse to produce it. One more example. As Ms. Keenan mentioned, at the heart of this challenge is a question about whether all members of the state committee are expected to pay a $50 fee. And if so, whether members were notified about the fee and whether members did or did not actually pay the fee. Now, you would think the simple solution here is to go to the records, the financial records of the party, and see who did and did not pay. But I don't have access to those records. The chairman does, The chairman has access to the bank accounts and all the financial records, and Lord knows the FEC requires that we have a record of who gave us money and how much and when. And yet they have been unable to produce any records to demonstrate who did and did not pay the fee. And I mention this because I want you to understand that this is an intentional disregard for requests for information. This is an intentional obfuscation. Moreover, if the intention of Chairman Kelly and Vice Chair for Minority Affairs Joe Reed was really to build a diverse and inclusive party, a party in which everyone was welcome, a party in which young people are appreciated for what they bring to the table, a party in which every minority group is valued. If that was indeed the intention, why weren't efforts made to keep those people on the committee? When they realized, let's say for the benefit of the doubt, that those people had not paid their $50 fee, why wasn't an effort made to reach out to those people, to tell them about the requirements, to give them an easy way to pay the fee? And when they had to be removed, why weren't they notified that they had been removed from the committee? Why weren't the caucus chairs instructed to find new members and be ready to present those members for election at the next meeting? But none of that was done. Instead, when members found out that they were being excluded and disenfranchised that day, they tried to pay the fee and were told, no, you can't. There is no mechanism by which you could pay. How, I ask, could it be that there was no mechanism by which you could pay on May 6th, but you should have already paid? And after 53 people were removed unceremoniously and without notification from the committee, they insisted no one had lost representation. They said it wasn't a big deal. They said it didn't matter because they'd put some other people on the committee who looked the same. They said that the chair of the Hispanic caucus looked white anyway. They said there weren't enough Native Americans for them to matter. And since that time in May, when all those members were removed, no effort has been made to fill any of those vacancies for young adults, LGBTQ, Hispanic, Native American, and AAPI Democrats. We have met since then, and we have not had it on the agenda to fill those vacancies. This removal of membership was never about $50. It's important that you understand that. It was always about power. It was always about finding a way to undo the 2019 bylaws that, as they would tell you, were imposed upon them by the racist Doug Jones and Tom Perez. These are the words they used to talk about this in public. They refused to admit that those bylaws ever governed the Alabama Democratic Party. Dr. Reed has said so aloud. Not only did he not adhere to the 2019 bylaws, he bragged that he had not even read them and that those rules did not apply to him. I provide these details not to relitigate the details of this case. The time for that has passed. I provide these details so that you can understand what kind of remedy will and won't work. If the only action taken by this body is to direct the chairman to operate under the 2019 bylaws, there is no reason to think he will do so. Without enforcement mechanisms, they will continue the pattern of intentional disregard for the ruling of this body. They will continue the pattern of obfuscation and delay. They will continue the pattern of knocking anyone out of the way who stands in the way of their power. Therefore, the Eisner challengers request that you not only restore the 2019 bylaws, but also put into place additional accountability mechanisms. I have all of those in writing if you want them. The key point is we need to establish trust. Right now, we don't trust one another. And the best way to establish trust is to put in place guardrails that keep us accountable to one another and make sure that we all do what we said we were going to do. So I ask for your support in that. I'm now going to transition and put on the hat of April Hodges, one of the other challengers, and share with you a statement from the Hodges challengers. Dear Mr. Roosevelt, Ms. Moore, and other members of the Rules and Bylaws Committee, we offer this brief statement in support of the findings of Hearing Officer Keenan and request a remedy that will support a strong, united, authentically diverse Alabama Democratic Party that is prepared to run competitive candidates and advance policies that will benefit all Alabamians, not just the moneyed conservative elite whose stranglehold on power keeps Alabama at the bottom of so many lists. Hearing Officer Keenan's findings are correct in most ways, including that the May 6th bylaws were not fairly adopted and that they imposed unfair structural barriers to party participation on Alabama Democrats who are AAPI, Hispanic, Native American, young adult, disabled, or LGBTQ. Our challenges proved by clear and convincing evidence that what happened on May 6th was wrong and must be reversed so that we can again operate under the party's previous bylaws. We ask that you affirm those key findings in your decision. Real progress for Democrats in Alabama will require a remedy much more substantial than just reimposing the previous status quo. It will require Democrats to expand on the work we have already done by building effective coalitions and working thoughtfully and in good faith with our partners of every background. Coalition building is hard work, but we know it can be done because we have done it before. We will do whatever it takes to build and rebuild each bridge, to invest in our state party's infrastructure, and make Alabama a better place for ourselves, our children, and our neighbors' children. With a new congressional map for Alabama approved by a federal court just yesterday, we are excited and hopeful as we prepare for 2024 to do what it takes to elect another Alabama Democrat to Congress. But we need your help to ensure our work stays on track and ensure that every person is represented and welcomed in our party. To that end, we request that you support us by implementing the remedies requested in our challenge and by instituting a 36-month monitoring and oversight period. These remedies would help Alabama Democrats focus our time, energy, money, and resources on our true goals, winning elections and bringing needed reform and improvement to our state. Thank you for your time.
Thank you, Ms.
Eisner.
I mispronounced it before. I apologize.
Okay.
Mr. Young?
Hey, y'all. It's good to be among Democrats. My name's Ralph Young. Not the first time I've been here. I hope it's the last. I really hope we can find a solution that is more lasting than what we struck in 2019, because diversity matters, and particularly in Alabama. Last time I was here, I testified that it's difficult being gay in Alabama and more difficult being gay in my state party. We've made a lot of progress, but there's more to be done. So, I was really encouraged with the new bylaws. Last year in 2022, we constituted our new party under the bylaws. It was diverse. Everything was going well, and then things went off the rails. We had meeting after meeting after meeting with leadership trying to pass bylaws that would roll back the caucuses. After 3 meetings, the 4th time, they simply threw off the people that were in the way. They said it was for a fee, but it was no more than a pretext than controlling the vote. They suppressed the vote to get the bylaws that they wanted, that the DNC had previously ordered to be required. It's just not right. In the intervening time, Dr. Kelly has sued in state court. He sued in federal court. None of the court systems will hear party affairs. This is the only body, the only recourse we have. There's nowhere else we can go. The RBC is the place. We need your help. I want to talk about remedies, because there are things that you can do that will help. I think it's quite clear at this point that the meeting's thrown out, and so are the bylaws. But that's nothing more than a mulligan. That's just going to give the state party another chance to try and pass bylaws again. We can't have that. We've got to do more. First, we continue to have problems with membership list. We need to definitively get a list of members going forward for the meetings. It needs to be agreed upon by the challengers and by the party. We need to get it right, and we don't need any more surprises going forward. About this fee. This fee has been an issue in our state going back decades. I've been fighting Nancy Worley about it since 2012. We need a definitive answer once and for all so it never becomes an issue again. Because next year, my party is going to use the SDC, which paid a fee, to elect at-large delegates to the National Convention and 3 DNC members. And if there are any vacancies with the chair and vice chair, the same body will do that. The body is tainted because of the fee. There was a fee required to participate in the first place. They cannot vote upon any DNC matters. That fee must be done away with. Further, we need oversight. I've heard 3 years from Hodges challenges. It needs to be at least 5. We've got to reorganize again. We've got to reorganize after that again. In Alabama, we are accustomed to having oversight over all of our politics. DOJ is just a way of life with politics in Alabama. It's no big deal. We just need some help. Further, and my last point, there's been a whole lot of malice. This is not intentional. This is cruel. They have removed people for who they are and for their votes. And I don't think that's behavior becoming of a DNC member. So I am hoping that you will take my challenge and refer it to the Credentials Committee so that they can investigate further about the individual behavior of a DNC member.
2 minutes.
Thank you. I'm done.
All right. Good. Thank you. Thank you, Ms. Eisner and Mr. Young. Appreciate your presentations. Mignon?
I'd now like to welcome Chairman Randy Kelly and Vice Chairs Joe Reed and Ben Harris. You can come. The challenge party is now recognized to present their arguments. You have 20 minutes. As we did with the challengers, I will give you a warning when you have your 3 minutes remaining, and again when you have 1 minute remaining. You may proceed and welcome.
Good morning. Sorry, I've got a little frog in my throat. Good morning, and thank you. As you indicated, I am Ben Harris. I am the vice chair for county affairs for the state party, which means I'm the person who goes around and tries to develop our county parties, and fortunately that is going reasonably well. We'll be in Bibb County tomorrow, for those of you who know where Bibb County is, trying to get that party restarted. I want to go right to the heart of the hearing officer's report and right to the heart of what I believe the challenges are, and speak to some points on which there is no disagreement, and that the state party is prepared to do, and to do in a way that satisfies the DNC's requirements, satisfies you, and helps our party move forward on a united basis. There is no dispute, and the state party is prepared to pass or at least recommend and attempt to pass an amended set of bylaws with the at-large members who had the issue over the fee fully restored before the vote. That was a fee that was, initially imposed. The $50 fee was a fee imposed specifically by the previous chair, not by Chair Kelly. And those folks would be fully restored. The caucuses, to the extent that there is any doubt or concern about the existence of the caucuses, also would be fully in place with the percentage representation to which they are entitled, and would have the self-determination rights that they have always had. In other words, the ability to propose new members subject to approval by the SDEC at large, by the entire SDEC at a meeting. In other words, the way that this typically works, we have a quadrennial, a quadrennial organizational meeting each in August of a gubernatorial election year, and the caucuses meet 2 hours prior to the convening of that meeting. Typically, the caucuses meet at, I believe, 9 o'clock, and the main meeting starts at 11. And to the extent that there are vacancies or positions that need to be filled in order for a caucus to achieve its percentage representation, the caucuses meet at 9 o'clock, nominate people to be proposed to fill those vacancies, and then they are presented for approval at the 11 o'clock meeting. And that would be fully in place, as would the caucus's ability to do that at subsequent SDEC meetings. So there's no dispute on what I think are the three main points with respect to the hearing officer's report. In other words, that to the extent that the fee prevented participation, those members would be fully restored. To the extent that there are issues with the May 6th bylaws with respect to the representation of the caucuses or their self-determination rights, and to the extent that that needed to be clarified, made clear, made certain, and committed to, that the state party would work to have an amended set of bylaws, a clarifying amended set of bylaws proposed at a meeting in the very near future. In the very near future, prior to our primary is March the 5th of 2024. So that we would commit to convene the SDEC prior to March the 5th of 2024 and have an amended set of bylaws with which the state party is fully prepared to work with the challengers. Obviously, without getting into any specifics, we've had conversations outside of this proceeding, and that we would work to pass those, propose those, and have them passed by the full SDEC. Now, why is it important that we do this voluntarily, by agreement, and by working together? Y'all, I've been living in Alabama most of my life. I'm about to turn 60. It's tough. It's tough being a Democrat. It's tough working for the goals that we all share. We are a party that is split in two right now. Split in two right now. We have very good people. I'm out in the counties many weekends on Saturdays doing training and other things all over the state. And we have very good people who share the same goals, but who fall on different sides of this 5-year dispute that we have been having. who cannot get along, who cannot work together. This goes far beyond a dispute among some SDEC officers. Issues related to race, issues related to diversity in Alabama are very difficult, very difficult. The struggles of black Alabama citizens for representation in all walks of our society and within our party are difficult to do justice to in words. The struggles that we have had to achieve representation have been some of the most bitter and difficult struggles that are imaginable. There is a commitment by this party to achieve the diversity goals that we all share for all of the groups, all of the caucuses. This is about succeeding in Alabama is about adding in a positive way the diversity that all of the caucuses bring to the incredible base of black support that we have. But right now, we've got two different parts of our party at war with each other. That needs to end. It can end, and it can end today. We respect the hearing officer's report. She did a wonderful job at the hearing. She heard us for 9 hours. We appreciate that. We appreciate your hearing us. We ask that you give us the opportunity. Give this party the opportunity, understanding fully what the goals, what the requirements are of this body and of the DNC in terms of diversity representation, understanding the issues with the fee, understanding the issues with ensuring full representation for all persons in our party. Give us the opportunity to develop an amended set, a clarified set of these bylaws, because there is no intent to discriminate against anyone. Give us the opportunity to end, I heard a reference to the term malice. There has been, and it's flowed both ways in this process. The 2018-2019 process by which the new bylaws were enacted, and many of you in this room are familiar with that, I'm sure. But we lived it on the ground in Alabama, and it was rough. It was very difficult. I was the recipient of contact that was very offensive about how I was expected to vote. And if I got that, I can imagine what happened with other members. And it has created bitterness and division that we need to end. It is hard enough doing what we're trying to do in Alabama. We are on the cusp of some opportunities. The cities have become decidedly Democratic. Most of our cities, most of our major cities. The university towns are on their way. If we continue with this county party building program, I believe we will have in a few years 67, that's how many counties we have, well-functioning county parties. But we've got to end this division. We've got to. We are committed to making sure that the bylaws comply with the requirements that the DNC has. We need the opportunity to reach that by agreement and not by one side winning and one side losing. We've had too much of that. We need every vote that we can get in Alabama, and we need all of the folks who move that vote in Alabama working enthusiastically to do that. Right now, we don't have that. Right now, we don't have that. We count on folks who help us to move, among other things, the black vote, to be enthusiastic about helping getting our voters to the polls. With this division and this bitterness, it is very difficult for that enthusiasm to be where it needs to be for us to achieve everything that we need to achieve in Alabama. So, in summary, again, no dispute and a full commitment to amend the bylaws, assuming the SDEC would pass them, and I believe they would, to restore the caucuses with the full self-determination rights, to restore the at-larges to the extent that there was any issue with related to the fee. We certainly can work out whatever is necessary and equitable with respect to the fee. It is a long-standing thing that all of us, myself included, paid, but it's something that we can certainly work out. Give us that opportunity. We would commit to do that prior to the March 5th primary. If we were unable to do it, we'd be right back and you could take whatever action you needed to take. But we are here. We're here to make a commitment to get this resolved and to get it resolved in a way that will unify our party and end, or at least begin to end, the very hard feelings that have existed over the last 4 or 5 years. Thank you very much.
What you feel here is that we took over the party leadership at an all-time low. They hadn't met in 3 years, not a single meeting. You had deep racial divisions based on the 2019 bylaws. But we hadn't discriminated against anyone. Majority of our DNC members are white. The majority of our staff is white. We only have a single black DNC member, and that's Charlie Staten. We don't have a black woman on the DNC. And we don't have any history of discriminating against anybody. In fact, the movement of blacks in Alabama made it better, not just for blacks, but for LGBTQ+, for Native Americans, for women and other disenfranchised people. And that's the history that we have. And just to say that we're discriminating is a kind of projection. We have done all we could to do to reach out to other disenfranchised people. And the party was at such an all-time low, it had one of the worst losses ever in the history of the state of Alabama. They didn't have a get-out-the-vote plan. In fact, the party was broke. We had to borrow money to travel to the conventions. And when Eisner made an arrangement with the hotel for this screen, she didn't contact me. She made the deal herself with the hotel. And I didn't know what the contraption was. And I hadn't checked with the treasurer. And so I told her she needs to be responsible for that. I didn't know who was going to pay for that contraption. And we don't have a problem with anybody that's physically challenged. And so I just want to make sure that we set the record straight. So you got a lot of misinformation there. And you got a lot of hidden agendas, even with this specific challenge. But I agree totally with Ben. We agree to those issues in order to heal and build the party, because we're in a great time. It's a great time for Alabama. We revitalizing our parties. We've revitalized almost a half a dozen parties. We have a very intensive and intentional training program in place. We just re-elected the first black mayor of the city of Montgomery. The Democrats in Mobile, Alabama, has just fought to save a black voting age district in Mobile, Alabama. And of course, the Supreme Court just ruled in our favor about another predominantly black district, congressional district. So we got a lot going on in Alabama. And we are in the process of building from nothing, really, building from scratch in Alabama.
I assume am I recognized, Mr. Chair? Okay, thank you.
Yes, sir.
My name is Joel Reed. I'm chairman of the Alabama Democratic Conference and vice chair for Minority Affairs for the Alabama Democratic Party. The Alabama Democratic Conference is a 63-year-old black organization that was founded in 1960 to help John F. Kennedy in the democratic process. I won't go any further than that. It is the backbone of the Democratic Party in Alabama. It's been that way. It helped him get elected and so many other Democrats. I want to move forward because no time is not our friend. I want to make it very clear as to what I see. I'm a retired union leader. I spent 47 years working for the Alabama Education Association. And then when I retired, the last 12 years I've been retired, I've given every day free to the Democratic Party. Every day free, period. When Randy Kelly was elected chair, the other side and this side, some of you installed, left, cleared everything out, no records, nothing, no money, nothing. We had to go to the Black Caucus even to seat the secretary. That's how bad it was. I'm not going to spend time on that. This issue comes down to one fundamental issue, and it's rooted in racism. It's deep in racism, and it's there because there's nothing in Alabama we've gotten that blacks didn't have to sue for or fight for. We had to fight like hell to get it, and fight like hell to keep it. And that's what we are doing now. I don't apologize for being a strong Democrat. I go way back, and that's not what you're here today. But I was Hubert Humphreys and Ed Musker's National Committee for Educators back in 1968. That means I'm an old man, but that's all right. My mind is good. Now, I want to make a couple other things. I want to first let the record reflect, I don't believe, in all due respect to all of you here, that the National Democratic Party has the power, the authority to substitute a constitution for any state. If they can do it for Alabama, they can do it for yours. Now, I do believe that the National Democratic Party has a right to enforce the rules of the party. I do believe that. But to come in and say, well, you going to take this constitution or that constitution, the National Democratic Party does not have that authority, and that's one matter being litigated in court now. I think what you're doing, some of it violates the Voting Rights Act. I think it violates Section 2 of the Voting Rights Act. We got some very serious problems, which we don't need to keep beating the drums about. We need to try our level best to try to pull them together. What the challenges are, the challenges lost. They were with the other side, I'll call it that for convenience. They were with the other side 4 years ago. I spent the last 4 years, and this all of us here, trying to, quote, put out little fires when we ought to be putting time organizing. We ought to be putting time organizing. But that's what we have been doing. We don't need to do that anymore.
Mr. Reed, unfortunately.
My time's up?
Yes, sir.
Oh, I thought I had a little more, but I yield. Yeah. Okay.
Thank you, sir.
All right.
So, thank you, Mr. Harris, Mr. Kelly, Dr. Reed, and thank you to all of the presenters this morning. for your time and your thoughtfulness regarding these issues. I know our committee likely has some outstanding questions, so I'm going to invite Hearing Officer Keenan and Ms. Eisner and Mr. Young to return to the table so the committee can ask questions. The committee has 20 minutes. During this time, members may address questions to each party's counsel or representatives or to the hearing officer. Members, if you have any comments or questions, please stand your name tent upright. We will do our best to call on everyone, but please be patient with us. Mr. Ray.
I have a question for the challenged party. Ben, I appreciated many of the things you said that you were willing to do as a party. I was curious, would you be willing to accept a DNC monitor to help with that process and oversee that process?
Well, I'm just Vice Chair of County Affairs, so I don't know that I can speak for the party. I think generally speaking, what you're hearing here is a spirit of wanting to get this resolved in a I don't know if amicable is the right word, but in an agreed way. So I think we would be open to just about anything. I would certainly, I can't speak for the party as a whole on the DNC monitor question, but I think generally speaking, the idea of doing what's necessary to get to an agreed solution would be very well received.
I guess I'll ask that then to Chairman Kelly. Would you accept a DNC monitor to help facilitate any of these changes? Thank you.
Other committee members' questions?
Yvette has her tenant.
Ms. Lewis?
Thank you so much, Yvette Lewis from Maryland. You mentioned the challenged parties. You said that you would be willing to do all of these things, but you did not give a date. You said before the March 5th primary. It's very open-ended, and I'm just curious as to, when what your deadline is.
We would have to, I believe, to get an amended set of bylaws passed, they would have to be passed by the full State Democratic Executive Committee, which would require the convening of a meeting, which takes time and notice and all of that, which is why we set it out a bit to March 5th. But March 5th would absolutely, Ms. Lewis, would absolutely be sort of our hard deadline, and we would have it done prior to then, because we certainly don't want to be holding an SDEC meeting on primary day. So we would schedule an SDEC meeting forthwith. I mean, I'm a lawyer by trade, so I'm careful with my words here, but forthwith to propose a new set. Now, they would have to be, I think, negotiated. I mean, in other words, we would have to have time to get to a set of bylaws. We don't have a document right now, and we certainly would want input from the challengers, and they're certainly entitled to that. But I think we could get to a document. What I would really like to see is a motion by, say, Dr. Reed from this side of the table, and a second by this side of the table on an agreed set that the SDEC could pass. And I hope we can get there, and I believe we can, and we would schedule that meeting, as I say, forthwith.
And I guess my next question is, who would be involved in crafting these bylaws that with the amendments and the changes that you want to make?
Well, I think there's a lot of experience at this table. Mm-hmm. And so without saying absolutely definitively, because there could well be others, but I think each of the challengers, and I know Dr. Kelly and Dr. Reed bring a lot to the table and a lot of experience, and we've all been working on this. And if we can get that done, I think certainly this group, Ms. Hodges, who's not here, but who has been very productive in her discussions with me, I think would need to be a part of that. And there have been others, but I think we would have a good group that could
And
work.
I guess my next concern would be, would any of the people that are affected, these people that were excluded, for lack of a better word, would they be included in the crafting of these new bylaws, since they would be affected? Let me tell you why I asked that question. I think that I sit here as the poster child for what representation means in a state. because we expanded our state in a way. We now have the most diverse team that we've ever had in elected office in the state of Maryland, and my fabulous Governor Wes Moore, and I never miss an opportunity to say that, as you all know. But not only Wes Moore, but our Lieutenant Governor, our AAPI first ever in the state of Maryland, our AAPI Lieutenant Governor, first woman comptroller, first African American Attorney General. And it was because we expanded in the state of Maryland that we have this representation that is inside the room and making the decisions. It's not just enough to have the representation. You want the representation to be able to make the decisions that affect all of our communities' lives. So that's why, if I could just finish, and before I'm cut off, I know you want to respond, but just let me finish, and then I'll listen. So it would be a concern to make sure that people that would be affected by these new bylaws have a say in these new bylaws. We expanded. We have diversity leadership councils in the state of Maryland, and they have a seat on our executive committee. We have expanded our numbers and our outreach, and as a result, had a historic election with turnout from these various constituency groups that we have expanded and opened up our party to. So that is why I'm asking the question, would they be a part of the discussion in crafting what you want to do to bring these positive changes about? And I commend you for being willing to do that and to even open this up and have that discussion. So let me begin by saying thank you for that, and just want to be sure that people that are affected have that voice that you're talking about.
Yeah. You're going to, I want to respond so we don't misunderstand what we had.
Yeah, yes, ma'am. I would just say that just the short answer to your question is yes. So thank you.
In all due respect, the tail can't wag the dog. What I mean by that, these bylaws were passed by a sizable number, and it turned out that particular day many of our members weren't even there. The Democratic Committee now has over 100-something black people on it. It's about 30-something white, a little more. Now, the tail's not going to wag the dog. The majority got to rule. The minority got to be heard and respected. We're for that. But now the losers can't come back and rewrite the ticket. They lost. We spent 4 years. I spent 4 full years out there struggling, trying to make this thing work, and we're going to keep making it work. This man has done a good job. Randy Kelly appointed him to pull the counters together, because what we got to get in Alabama, we got to try to pull some more white folk back into the party. Black folk are carrying the party now. So what I want to say, and I'm going to stop with this. We don't want to say that, yes, sure, they can be consulted, they can have their input, but the bottom line is the minority is not going to write the new bylaws. And they don't write them in your state, they can't come to Alabama and write them in our state. On the other hand, they are entitled to be respected, entitled to have their fair share, and we are together. And I can tell you what, look at every committee we now have, and the people who are serving in a position will put that because black folks voted for them. The chairman and the rest of us worked to get them elected. So nobody's trying to keep them, and I can tell you right now, proportionately, there's a higher percentage. So nobody's trying to keep anybody from being elected, but now you've got a struggle that you people have missed. And that is the losers lost, and they are mad, and they're going to stay mad. And they come run to you every time they want something. They come to the Democratic National Committee, find some little technicality, and come and say, try to get some relief. Give it a relief. Give them a relief. But I'm simply saying to you, they are losers. We supported Ms. Eisner. We supported her. We, the Black Democratic Congress, Alabama Democratic Congress, she ran for Congress. We supported her. We supported other people. So what I'm trying to say, we did not support her for vice chair, but we supported her when she ran for Congress some time ago. Now, the point I'm trying to make, and I'm going to stop with this. Yes, everybody's entitled to their fair share, and they ought to get it. And if you look at the bylaw, in 2017, I proposed, and you go back and look at the bylaw of 2017, the affirmative action plan for what? Non-blacks in 2017, not just 2019. And the 2019 bylaws, you need to know that. And let me tell you what happened. Yes, they passed some 2019 bylaws, but what nobody said, that next week or 2 weeks ago, Nancy Worley called a meeting, and they were repealed. Those bylaws were repealed. They weren't passed, and those bylaws had a provision so you could amend the bylaws. We haven't taken the amendment process out, and I don't know when. So the point I'm making is that there we are. And this whole struggle of representation goes back when Bob Vance was chairman back in 1980. That's why we sued Hawthorne versus Baker. That was the case because black folk were being shut out. And we won. And now, last time around, would you believe we did not have to do a single at-large member for blacks? You know why? Because we went out and got blacks to run. We went out and got blacks to run. We didn't have a single at-large black to have to run for the last time around because we had our votes. And when you have your votes, you don't have to have an at-large.
So my question was to say to the county chairperson who's here and to all of you, would there be input, not the tail wagging the dog, but would there be input from people in terms of how the bylaws will turn out at the end? Let me finish. Whether or not you accept that input or not is strictly up to you. That was not my question. My question was, would there be input? He said, yes, there would be input. That's all I need.
Yeah.
I'm not talking about the past and what happened in the past. Yeah. I just simply said, would there be input? And you said yes. And it's up to you as to whether or not you accept that input. That was it.
Yeah. You have a rule here. You have a rule, and that's the rule. So everybody, and I think it's a good rule. I really wonder, some rules not so good, but these are good rules. Everybody is represented based on their performance, based on their numbers in the Democratic electorate. And this goes back to the reform many, many years ago. I think it's a good rule. We use your figures, the figures you put out, in drawing our delegation election plan up. We use nobody. If the bylaw that was passed on the 6th didn't take anything from that. And I know you played down the issue that the past office holder that we had put out a memorandum, told everybody you pay at the end. 9 months passed. Who the burden was on, it depends on who you talk to. We've always in Alabama had the burden been on the candidate. If you got to do something, you do 1, 2, 3, 4, 5. There's a candidate. But some parts it was on the party. When Randy Kelly took over, that Monday, we met following his assuming office. And we had nothing. But we working at it. And he said we had to borrow money. We surely did. From the Black Caucus. The Black Caucus didn't have any money. They had good credit. But no money. But we had to borrow money. We had to even house the secretary. The Black Caucus had to house the secretary. The Alabama Democratic Congress got its own building.
It didn't have any staff.
No staff at all. We used the Alabama Democratic Conference staff to move it on. So people doing a lot of talking. And who was out there opposing, fighting us, and criticizing us? One of the challengers. That's all it's about. People, I can promise you. No. We have done everything we possibly and going to continue to do it. And we're going to cooperate with the national part. We're going to coordinate with the chairs of the committee. We're going to coordinate with anybody who wants it. Come and look. Come and look.
Thank you.
So the bottom line is yes, we're for making adjustments to make it right. But now nobody's claimed the law's membership now. Nobody has claimed that. Except they said that the young people, those people, some, not all of them young, as I've been reminded so many times.
All right. Thank you, Dr. Reed.
All right.
Are there other questions from the committee? Yes, Ms. Brazil.
You know, I don't have a question, but I have a feeling that something here doesn't smell right.
That's right.
I'm a Southerner. You're going to take that from me. I've seen this battle from the time I was born. I felt it. I know what pain feels like. I know what it feels like to be discriminated against. I know what it feels like to not have a seat at the table. And I am proud that this party, this committee, has worked hard, very hard, to try to get it right, to open our doors, to put seats, even as Shirley Chisholm said, if you don't have one, bring in a folding chair. I want Alabama to be as good as Alabama promised when Dr. King took that march from Selma to Montgomery. And when people said, how long? And he said, how long? Because the arc of the universe bends toward justice. So I hope that you accept our help to bend this toward justice, to give everybody a seat, Joe Reed, because you made those rules possible, because you did put the time in to see what Alabama could become. Once blacks got in the room, we said, hell, come on with us. We brought everybody with us. We never told anybody to get the hell out. We said, come in, come in, come in, you're welcome. We are all here together trying to make not just Alabama, but the South and the North too, the West and the East Coast. I ain't excluding nobody. The benefits of diversity is in this room.
Mr. Chair, Madam Chair.
No, brother, I'm gonna keep my time for one more second. You had 30 minutes and what you've convinced me. And your 30 minutes, what you convinced me. And Madam Kim, what you've convinced me is that we want to help you all get this right. Because I want to see that extra district in Alabama go to someone who reflects who we are as a party and what we fight for as an institution. So please accept our help. We're going to help you. And if we got to put some nickels and dimes into Alabama, hell, I'll put some in there. Okay? I left Alabama last week. You know, I went down Auburn and Montgomery. And I told y'all a story. I praise you for not looking in the rearview mirror, the side mirror, but going forward. After Rosa Parks sat down, Fred Gray, the Durs, and everyone else, Mr. Nixon, Mr. Reed, your son was there, the mayor of Montgomery. I went to your riverfront. I enjoyed my entire trip. I even took home some biscuits and some chicken. It's good stuff. I don't know how y'all do it in Alabama, but we'll figure it out. But I left that state believing that one day when I come back to them rolling hills, I'm going to see a different Alabama. Joe, I love you like a brother, like a father, but you have always been a guiding force. Help us guide this future, a future that Dr. King saw and so many others, a dream that you even talked about when I first met you. We can recruit, we can expand, we can have new candidates, we can have new voters, and we can see a different Alabama. So that's what I am going to help you do. And I ask all of you to put aside, and it's painful, I know I got scars too, but I put aside what has been wrong so we can make it right and use those stories. Because the young people who are anxious to get in this room now, I know they're coming. They're right to come. I'm going to scoot over, make room for them. I'm not going to leave the room. No black person will ever be asked to leave the room, and no white person, no gay person, no Asian, no Jewish person. Do not scoot over. We got room for everybody in this party, and that's why I'm proud to be a Democrat.
Well, Chairs, I know I'm out of order, but I want to know if it's acceptable to take up an offering after what Donna had to say at the Bylaws Committee meeting.
I don't think I hear any further questions from the committee. In fact, I think we have launched into discussion. I'm going to call on members of the committee for their comments in this order. Ms. Lewis, Mr. Martin, Mr. Leone, and Jason Ray, Secretary Ray. Ms. Lewis, would you?
Yeah, the only thing that I would I think Donna really sort of said it all. I think that we need to recognize the importance of equal participation. And I think that that's something that we as a party should take very seriously, and as Donna said, help everybody get to that point of equal participation. You have indicated in your opening statement that you are headed in that direction. And once again, I want to thank you and commend you. And as Donna said, you know, we want to help. We don't want this to be adversarial. And that's why, you know, I quickly said, if people make recommendations, let them make recommendations. It's your choice as to whether or not you accept those recommendations. But this is how you expand and get people to feel that they are being heard. Just like all of us today want to feel like we are being heard, including you. People in your state want to feel like they are being heard. And you have indicated that that's the direction that you're going in. So thank you.
Thank you, Ms. Lewis. Mr. Martin, did you have a comment?
Yes, thank you, Mr. Chair, and thank you all for your presentations. I do think it's important I just want to comment a little bit on the fee portion of this, and this is just my personal opinion, but I don't believe that mandatory fees should be allowed at any level in our party. They are antithetical to our party values of inclusiveness and fairness and even core tenets of our representative democracy. And Dr. Reed mentioned the Voting Rights Act, and I think it's critical for people to remember that one of the key provisions of the Voting Rights Act is to eliminate poll taxes. And I'm not sure why we allow in our own party a version of a poll tax to be instituted at any level. Now, that aside, we know that fees are a barrier to participation for low-wealth communities, for marginalized and underrepresented communities who are trying to lift up voices and build power within our party. And so if we are, as a party, Mr. Chair, going to allow fees to be levied, I think it is critical that these fees are both, one, voluntary, or at a minimum, that there is a dispensation allowed for those who cannot afford to pay, and that fee is waived. Second, that there is always proper notice given in a timely manner if any fee is required to vote at any body in this party. I believe it's really critical that we do not allow the imposition of a fee to prevent people from having their voices heard within this Democratic Party. It is antithetical to everything we stand for, and that's my last comment.
Thank you, Mr. Martin. Sorry, this is for discussion only among the, this is a time for discussion only among the committee members.
With you, but it's already there.
This is a time for discussion only among the committee members. Mr. Leone? No? All right. Secretary Ray.
Thank you, Mr. Chair. I think one thing that I heard during this discussion that I think is important as we move forward with a path here is something that my office is very familiar with, which is the membership list and roster. And I think we heard from both the challengers and others in the hearing report and during the hearing about how difficult it is and how we need a definitively agreed upon list of who are actually members of the SDEC in advance of that meeting so that proper notice can be given and that we can actually know who is eligible to vote and who that is. I know here, at the DNC, for example, my office, we cut off changes to the roster 3 days prior to the DNC meeting so that we can have a definitive list and that all members can know who is eligible to participate and engage in the process. So I think, as we move forward here, I think it's really important that we have a definitive list of who members of the SDEC is, both from the caucuses and from others heading into a meeting. So as we consider this, I'd like to ask that as a part of our recommendation from the RVC that we ask that prior to a meeting of which any votes are going to occur on potentially amended bylaws or other processes here, that Chair Kelly works to compile an up-to-date list of all current SDEC members, and that each diversity caucus actually be asked to supply Chair Kelly with a list of its at-large members who have been elected, including their contact information, so that we can incorporate that into a membership list, and that Chair Kelly submit that final membership list to the co-chairs of the RBC and the challengers for review prior to issuing notice of the meeting to the membership. I think it's very important that we are all on the same page of who is an eligible voter and who can participate in this process. And I think that time is really important in this. And I know we heard, March 5th as a date that was thrown out, but I would encourage us to look at dates sooner than that. With the convention coming up, with all the pieces that we have, that gets us far too close to things. So I would think that we would want to look at a November 28th date or so for resolution of approved bylaws and that membership list fully submitted. And that's my recommendation.
Thank you. Thank you, Mr. Secretary. Mr. McDonald.
Thank you, Mr. Chair. I have 3 comments. First, I watched the 9-hour hearing, and I would be remiss if I did not commend the hearing officer for her patience, her collegiality, and working her way through it. The hearing itself did keep me awake even in the early morning hours in the Pacific Zone. It was an exciting hearing. Second, I know this committee and the DNC does not write bylaws for local organizations. That's not our job. It's not. We're not into micro-regulation. We do require, and the national bylaws require local bylaws to be consistent with our charter, and I hope whatever is done in Alabama will end up being consistent with our charter, so we don't have to discuss this again, but the details are not something that we dictate. And then third, and this is as much for all the other state parties as it is for Alabama, I was quite concerned that anybody even thought for a moment that someone could be denied the right to vote based on a failure to pay a fee. And that should not even be in the atmosphere of a thought. And I want to point out that state chairs and DNC members are delegates to the National Convention. They are in state bodies, executive bodies, often in plans are going to select delegates to the National Convention. All of these officers and positions are elected pursuant to bylaws, which are part of the process of electing delegates to the National Convention. And our charter says very explicitly that delegates have to be chosen through processes which, quote, do not deny participation for failure to pay a cost, fee, or poll tax. That is fundamental in any state party electing any of these positions that lead to the National Convention. How you do the rest of the business, fine, but the National Convention is very clear. People have got to be able to participate irrespective, and it may be voluntary, but if they say, I don't want to pay it, they get to vote. No, we just do not deny votes based on cost.
Thank you, Mr. McDonald. Mr. Heredia.
Mr. Chair, Luis Heredia, Arizona. I do want to take great exception at the fee because it does create a barrier, or even though that the hearing and the parties have agreed that it was not intentional with intent, it does have it can be used, and I guess in trying to, the outcome is trying to be maneuvered, or we end up having a situation that we find ourselves, it becomes a major issue in this challenge. So I understand the rationale, and that is in the process of that the National Party can't dictate what you do in your process, and that is the spirit of why a fee can be considered. But we also need to look at what is fair, what is right, and provide access to folks to participate. I have always shared this story of my personal involvement in the Democratic Party. I showed up at 16 at a border county to the Democratic Party. My parents weren't U.S. citizens. They were legal permanent residents, recent migrants into this country. But I showed up. And I always tell people that the party belongs to those who show up and work. And we should not put provide limits. I have struggled 20, 30 years to be in this seat myself. It takes work. I get elected by my state committee, but it's also not an easy thing. I have to do the work to get here. If I saw to get involved in the DNC, it took work for me to be on the executive committee, to get elected by one of the regional councils. There are no favors or shortcuts in this process, but I want to share this story because it's important that we don't create the barriers that really restrict the participation in our party. And we have to understand history, and I'm in awe at listening at the struggle to try to correct what the wrongs of the Alabama Democratic Party. But our party is also an inflection point to the future. And for our future to be true to our values, that because of the lessons that we learned in history, we have to look at that future. And if the Alabama Democratic Party is changing as well, and there's a young Latino that is 16 years old or 18 years old and wants to be involved in the Democratic Party, I sure hope that somebody could grow up to be and be in those seats making decisions for their state party. So I really want to just emphasize another thing. When you do provide posting and you look at your bylaws, I sat on the credentials committee previously, and this issue of when to post is always an arbitrary, but I understand the deadlines and the notices. I really urge you to set a particular Saturday or a particular month in your bylaws that these meetings of selections would be consistent, and so the party itself, we can't dictate that. You are absolutely correct. This body cannot dictate the date or time where these elections are going to be held. But the spirit of us having just a document that shows when the officers of our party are going to be selected, let's try to have that be prescribed. It doesn't have to give you a date, just at least a month or a Saturday or whenever that convening is going to happen. So there is no question in somebody that wants to run for a particular office that is just going to be set in stone, and they could organize to get elected and they could understand the rules. But when you wait up to the very last minute and the way of posting becomes X, Y, and Z, and then we're seeing this case in a credentials challenge, I just feel that is not the spirit of what we intend in our charter and in our bylaws.
Thank you, Mr. Heredia. Ms. Lewis?
So thank you, Mr. Chairman. I would like to support what Secretary Ray has said in terms of having the amended bylaws and a member list by November 28th, and just to make sure that we can meet the deadline and not run into the deadline, I would like to recommend that you convene to vote on the proposed amended bylaws by February 1st. I'm sorry? Okay, well, just a minute. I would like to recommend that you convene a vote on the proposed bylaws by February 1st, if it's at all possible to get that done. I'm just concerned about the open-endedness of March 5th. I know that's when your primary is, and once again, I would hate for you to have to rush through a meeting and rush through the process and, not really have everything fully in order that would be to the benefit of your state. And I'm just thinking that if you allow yourself the time to get this done, and if we put a date certain on it, it might be easier to get it done so that your delegate selection plan, everything that has to be in place is in place, and there are no further issues. I would, as someone who's worked on this, I would like to see Alabama now to move forward. You've got a really, really exciting opportunity coming your way. And I just hate to see you tied up in these kinds of meetings over and over and over again. It's time to get about the business of really electing people in Alabama that are going to represent the Democratic Party values. So if we could agree on a date, I think that would really be helpful to everyone.
Thank you, Ms. Lewis. This portion, I'm sorry, Ms. Eisner, but this portion is only for discussion among committee members. For everybody's awareness, we asked staff to begin drafting a resolution reflecting the findings of the hearing officer's report, and they've been working through this discussion to incorporate your thoughts into the document. So Veronica, is the draft resolution ready to be shared, or do you need a few more minutes? 30 seconds. Okay. So thank you all to all the parties and to the hearing officer for your participation today and your great work. We now have the resolution up on the screen, and we will read it aloud as well. This is a resolution of the Rules and Bylaws Committee of the Democratic National Committee. In the consolidated challenges of April Hodges et al., Tabitha Eisner et al., and Ralph Young, known all collectively as the challengers, certain actions taken by the State Democratic Executive Committee of Alabama, referred to as the SDEC, and Randy Kelly, chair of the SDEC, collectively the challenged parties, before the Rules and Bylaws Committee of the Democratic National Committee, the RBC hereby resolves. Whereas the SDC amended its bylaws in 2019. Whereas Randy Kelly was elected chair of the SDEC on August 13, 2022, pursuant to the 2019 bylaws. Whereas the SDEC met in Montgomery, Alabama on May 6, 2023, which we'll refer to as the meeting. Whereas a vote was held at the meeting to amend the 2019 bylaws. Whereas the bylaws amendments were passed by the SDEC members who were permitted to vote at the meeting by a margin of 63 to 49, creating the 2023 bylaws. Whereas 3 challenges were filed with the DNC concerning the conduct of the meeting, the vote to amend the bylaws, and the contents of the 2023 bylaws. Whereas in supplemental filings, questions were raised about the passage of Alabama's delegate selection plan, including who was allowed to vote on the plan's approval. Whereas on June 17, 2023, the Executive Committee of the DNC referred the challenges to this Rules and Bylaws Committee for further review and resolution. Whereas pursuant to the referral, the co-chairs of the Rules and Bylaws Committee adopted rules of procedure to govern the committee's review of the challenges and appointed Ms. Kim Keenan of Washington, D.C. as a hearing officer. Whereas on September 8, 2023, the hearing officer held a 9-hour evidentiary hearing in Washington, D.C., where each party was given an opportunity to present evidence and arguments in support of or in opposition to the challenges. Whereas the hearing officer issued her findings of fact to the Rules and Bylaws Committee and the parties following the hearing. And whereas the parties presented additional oral argument to the RBC at its October 6, 2023 meeting. Whereas during oral argument, the challenged parties committed to the members of the RBC to taking certain steps to address the key issues raised by the challengers. Now, therefore, based on the record and proceedings before it, which indicate that 1, Chair Kelly has not maintained a complete and accurate list of SDEC members during his tenure as chair. 2, requisite notice of the meeting was not provided to a number of SDEC members, including many at-large members of the diversity caucuses. 3, at the meeting, current SDEC leadership attempted to impose a $50 fee on at-large diversity caucus members without providing them with prior notice of the fee, or that failure to pay the fee could be grounds for removal from the SDEC, and without a mechanism in place to allow these members to pay the fee once they were made aware of it. 4, had these members received proper notice of the meeting and the fee, more members of the SDC may have been able to vote, may have been able to participate in the meeting, thereby altering the outcome of the bylaws amendment vote. And 5, the 2023 bylaws conflict with the DNC charter and bylaws by denying certain diversity constituencies an equal opportunity to elect at large members of their choice. And based on the challenged parties, let me begin that sentence again, and based on the commitments the challenged parties made to the RBC at its meeting, the RBC hereby orders that a new vote on the SDEC's bylaws be held, at which all duly elected members of the SDC be permitted to participate in accordance with the terms of this resolution. This vote must be held in accordance with whichever set of SDEC bylaws Chair Kelly determines to be in effect, subject to the following procedural safeguards. 1, the challengers must be given an opportunity to review the proposed bylaws and provide comments before they are put to a vote. 2, all duly elected members of the SDEC, whether elected pursuant to the 2019 or the 2023 bylaws, including all at-large members of the Hispanic, Asian Pacific Islander, Native American, youth, LGBTQ+, and disabled persons caucuses or committees, must receive 10 days prior written notice of the meeting and be permitted to participate and vote in the meeting. 3, prior to the meeting at which these votes will occur, Chair Kelly must compile an up-to-date list of all duly elected SDEC members. Each diversity caucus or committee must be asked to supply Chair Kelly with a list of its at-large members who have been elected by the full SDEC, including their contact information, for Chair Kelly to incorporate into the membership list. Chair Kelly must submit the final membership list to the co-chairs of the RBC and the challengers for review prior to issuing a notice of the meeting of the membership. 4, if a membership fee is imposed, all members must receive 10 days prior written notice of the fee and be given an adequate opportunity to pay it, except that any member who is unwilling or unable to pay the fee must be permitted to vote without paying the fee. Chair Kelly must propose a set of revised bylaws compliant with the DNC Charter and bylaws, and provide the SDEC membership list to the co-chairs of the Rules and Bylaws Committee and the challengers by November 28, 2023, and a vote must be held on the compliant bylaws by February 1, 2024. The co-chairs of the Rules and Bylaws Committee are hereby authorized to take all reasonable actions necessary to enforce the terms of this resolution, including but not limited to the appointment of DNC representatives to assist the SDEC in meeting the requirements of the resolution. Is there a motion to adopt this resolution to begin discussion? It's been moved and seconded. The floor is now open for discussion by the members. Mr. McDonald.
Excuse me, I just have a question. The part of the resolution which says whichever set of bylaws Chair Kelly determines to be in effect is a little confusing to me. Are we holding that the second set have been validly adopted and therefore he gets to choose? Or are we saying it's a local decision whether they've been validly adopted? Or how do we resolve what looks to me like it might be an inconsistency between the hearing officer's recommendation and a little ambiguity in what we're saying? And Andrea, I apologize for not asking this question sooner and putting you on the spot. But
So as drafted, this resolution leaves the determination of which set of bylaws to use, however they were adopted, up to the current chair of the SDEC. It's open for discussion, but that's the way it's drafted.
Andy, do you have any further context?
Yes, so the reason that the resolution is drafted in that way is that the RBC doesn't necessarily have the authority to tell a state party what its bylaws are. We do have the authority to tell a state party when its bylaws are not compliant with the DNC charter and bylaws, and to assist the state party in remedying any discrimination that may have occurred in the passage of those bylaws. And so if Chair Kelly deems the 2023 bylaws to be in effect for the purpose of this meeting, he can conduct the meeting in that way, including the threshold for the passage of the amendment, the notice requirements, and things of that nature, but subject to the requirement that all at-large diversity caucus members be allowed to vote.
I guess I'm not sure that I agree with that analysis. If we think that excuse me, a set of rules and operating procedures have not been adopted in accordance with the charter, I think we do have the right to reject them. I'm not saying we should today, because I think this is a complicated situation. I hope the parties will work it out locally with as little interference other than maybe monitoring from us as possible. But I'm not sure I want to take the position that we have absolutely no authority to tell a group that they have simply violated all procedures and adopted bylaws that without participation, particularly when this relates to a poll tax issue. So I'll just leave it at that. We're already running over time, and I don't want to.
So we do not say in the resolution that we do not have the power to choose between the two. We leave that choice, however, to the current chair. That's the way we have resolved this, rather than attempt to go forward further at this time. But I hear you correcting the record to say that we have not done this for future decisions. Okay. We're not going to go into that. Okay. Yes. Mr. Spade.
On number 4, in reference to the membership fee, I kind of wish we were stronger in the language. And so I would ask if it would be amenable to the drafters that we just simply say, no fee shall be imposed to vote.
So my understanding is that a number of state parties have fees for participations in their state conventions, but they also have processes for waiving that fee. So that if we were to go further than that, I think we would have to take a more comprehensive look at this. So what we're trying to say here is, again, we're leaving to the state party whether there is a fee, but that it's up to the participant to decide whether they can or choose to comply with that fee. Mr. Burgos.
Fees in other state parties are used basically as a fundraising mechanism, not as a right to participate in a voting process. And I think that should be really clear on our rules, that we're not going to charge anybody for the ability to participate in a voting session. If they want to do something else in a convention for raising dollars, that's another thing. But in voting, I think that needs to be addressed in a clearer fashion.
So, Mr. Burgos, are you proposing that item 4, an amendment to item 4, to say that no membership fee may be imposed, period?
That is correct.
You're moving that. Is there a second to that amendment?
To vote.
Is there further discussion?
The word should be in there, to vote.
All right. No membership fee may be imposed in order for a member to vote in the meeting.
That is correct.
It's moved and seconded. Any further discussion? All those in favor of the amendment say aye. Aye. Opposed, no. Okay, that's done. Mr. Martin, did you have a further comment?
Yes, thank you. And first off, I want to thank the co-chairs of this committee, as well as all of the party affairs staff for their work on this, and of course the investigator Keenan, who conducted the hearing. It's a very important conversation we're having. I just want to thank Tonio and others who raised this question of the fee. And I do want to tell you, though, that it is important for state parties to ask for voluntary contributions when people attend conventions, and we all do that. But it's not, I want to clear the record a little bit, and this is going to lead to a point here. almost every state party I know only requires a fee as a voluntary contribution, not as a requirement to participate in party affairs. And if there are states that are doing that, then they are violating, again, all sorts of principles of inclusiveness in our party. And so this is what I was going to say before this conversation ensued, which is, because of the ambiguity in our DNC charters and bylaws, I would like further action on this to be referred either back to the RBC or whichever body to actually make the language within our charter and bylaws very clear that there can never be a fee imposed on anyone when they're a voting member, a duly elected voting member of a body representing people who've elected them. They should not be forced or required to pay a fee. And I don't know if I can make that as a referral back at some point. I know this is potentially binding the hands of a future RBC, but I think it's worth this RBC going on the record saying we suggest that the next RBC duly composed, whoever's on it, that they take this issue up, because the ambiguity allows state parties to interpret it as they will, and we need to take it out and make it very clear what our party stands for, and we do not stand for a poll tax.
What I'd ask you to do, Mr. Martin, is to submit a charter amendment. Given our timetable, that may not come up until just after the convention, but that'll get it on the books, and our secretary will be sure that it carries forward. Ms. Lewis.
Yes, I just wanted to respond to Mr. McDonald, to David, and your concern. I think we should give the Alabama Democratic Party some grace. They did come here in good faith today and say that they wanted to make these changes. Let's see what that looks like. I understand your concern, but I just want to be sure that, you know, we honor the spirit with which they came into this meeting today. And
Yeah, no, and that's why I wanted to make it clear that I was speaking to all parties. I understand the confusion that Ken is talking about, and I do hope we clarify it, but that was not directed at the Alabama party per se, because I doubt that they were the only state party that might have had a misconception about it. It was clear from the record that the fee is actually kind of complicated because of some people being elected on the public ballot and so on. And I don't want to go into extended discussion, but it was not
No, that's not what I was
Alabama,
referring to. I thought you were talking about him having a choice as to whether to accept the 2023 bylaws or the 2019 bylaws. And what I heard when they were sitting at the table was that they are going to be making adjustments and amendments to the bylaws. So let's just see what that looks like. And maybe I misheard you.
No, my concern is what we're creating a record for the next challenge that comes in this written document.
Thank you for the clarification.
And we've corrected the record, that's all.
Great. All right. Is there any further discussion from the members? Hearing none, I'm going to move toward a vote on the resolution, which calls for a new vote on the bylaws and the delegate selection plan. This vote must be held in accordance with whichever set of SDEC bylaws Chair Kelly determines to be in effect, and all duly elected SDEC members as defined in the resolution must be permitted to vote. The SDEC must comply with all terms of this order by November 6, 2023. Hearing and seeing no further discussion, I'm going to ask for a vote on the motion as amended. All those in favor, please signify by saying aye. Aye. Opposed, say no. I do not hear any noes. The motion is adopted. Thank you, members, as well as all participants, for your thoughtful discussion and consideration of these complex issues. I appreciate your commitment to the committee and to the values of our party, which is really what this discussion is about. The recommendation of the committee on these challenges will be submitted to the full Democratic National Committee during our report on Saturday. Do we want to take a two-minute stand-up break, and then we will move forward to the next portion of our meeting? All right. Okay.
members take their seats, please?
No, there's Carnahan. She didn't leave. So that's
Will the members take their seats? And we're going to do housekeeping. We're asking all members that are not chairs to stay.
Yeah, we recognize the caucuses are starting. We're sorry that this is
Yeah.
running over. Appreciate the time. Get them at the table.
We'd like to call the Missouri delegation to the table, please. And to the RBC members, if you're not chairs, unfortunately we have an overlap. If you're not chairs of a caucus, if you could remain so that we could finish our agenda items, that would be great. And we thank you, and we will try to go as quickly as possible. Thank you. Thank you so much. So, Jim, you want to?
All right. All right. We'd like to welcome the representatives of the Missouri Democratic Party Thank you for welcoming us to your state and city. And we know you're under some time constraints, so we'd like you to make your statement now. We're not going to go to the full discussion of your plan until a little bit later. But please go ahead and introduce yourselves and let us
Thank you. Thank you, Mr. Chairman and Madam Chairman. Thank you for having us. We're thrilled that you're here in our city. I want to change our remarks up a little bit to accommodate our mayor, who's here with us, who has to leave shortly. So I want to go to her right away. But just as a
So I know who you are, but why don't you say so the whole committee knows?
Absolutely. Russ Carnahan, chairman of the Missouri Democratic Party.
Former member of Congress?
And former member of Congress.
Right.
Have Mayor Tashara Jones here to my right, our executive director, Matthew Patterson, over to the right. We have representative here with us, Joe Adams from St. Louis County, and the state senator, Angela Mosley, also of St. Louis County. And I'll just say by way of introduction, I want to give a special thanks to our Missouri Affirmative Action Delegate Selection Plan and their members, our chair, Gunnar Johansson, who did so much of the work on this to really help expand access, improve interest, and model after other state successful plans after being really stuck with a really tough state law due to our Republican state legislature. And again, out of the interest of time, I want to return the mic over to our mayor and host here in the city, Tashara Jones.
Good afternoon, everyone. Again, I am Mayor Tashara Jones, and I am also on the executive committee of our state party, here to support our plan to make sure that people have access to the ballot. As Mr. Carnahan recently spoke, and you'll get more information from speakers after me, we want to, our Republican state legislature recently passed a bill to take away access to the ballot, and we are putting forth a plan to reverse that, to make sure that we try and reinstate a state primary on the Democratic side to make sure that people can exercise their right to vote. We know that caucuses have very little participation, and that's not what our party is about. So we are actively trying to present a plan to make sure that people have access to the ballot through ranked choice voting. St. Louis already does approval voting, which is something similar in our local elections. So our St. Louisans are already used to this concept, and we are hopeful that we can have a state primary next year in March for the 2024 election.
Clarify there for a minute. Hopeful that you can have a primary in the next cycle, you're saying? Yes. In 2028? No, you're talking about?
Yeah, in the next election.
Yes.
Not 2024. We're stuck with the caucus
that's
system
what I wanted
from
to
the
clarify.
legislature right now. And to really fill that story out, I want to turn it over to our legislators here, Joe Adams, who's been our ranking member on the House Elections Committee in the Missouri Legislature, to give some background on how we got here. Representative.
Yeah. Good afternoon and welcome to St. Louis, all of you. I'm Joe Adams, State Rep for the 86th District. I am the ranking member of the Elections Committee. I've been that for a number of years. That means I'm in the minority. Missouri has majority Republicans running the legislature. And when I say they run it, they run it. They jammed through in 2022 a piece of legislation called House Bill 1878. It is an election omnibus bill. It has a variety of things. Some of it has already been enjoined by the courts, but not all of it. And one of them that they put in there was to get rid of the primary, which the state paid for, which would have been in March. The person pushing that was the Secretary of State, Jay Ashcroft. Jay Ashcroft has been playing with election laws in the state of Missouri ever since I've been on the election committee in the state legislature, and I've been fighting Jay on that all along. And it is not an easy fight. What that did was basically save the Secretary of State money in his budget so he could spend it on something else, and it cut it out because he would be paying for the election. We fought it. It came back this legislative session to go back to the primary. Also, the Republican committee, state committee, and the Democratic state committee asked for the primary to be reinstituted. And we could not get it through the legislature. The Secretary of State has a lot of friends, and they kept messing it up, and so it never made it. So that's where it's at.
Thank you, Representative. And now State Senator Mosley from the Senate perspective and her work there on these election issues. Senator.
Hello, I'm State Senator Angela Walton Mosley of the 13th Senatorial District. Just to ditto what Representative Joe Adams said, we are constantly fighting against the Republican Party when it comes to voter suppression bills and anything to deter Democrats from fighting, from voting for elections. I would like to see no excuse absentees for the primary so that we can make sure that the voters' voices are heard for the presidential race. Also, because most people, well, not most people, a lot of people do work on Saturdays, so we do need to be able to have some type of way for people to be able to vote by mail. So I'm pushing for that aspect of the bill.
Great. Thank you, Senator. And with that background, we're stuck with this. We're in the position of trying to make the best of a bad situation, make lemonade out of lemons. And so none of us like the idea of having a caucus only because it's so restrictive. You know, if you're a working family or have child care issues or disabled or elderly or you're in the military, you're not going to be able to show up at a caucus only. So we looked at other state examples. And so what we've come down to, and again, thanks to our great committee that went through the detail on this, really a hybrid model that has the in-person caucus with a mail-in ballot option. And we think that's, again, making the best of a really bad situation. And believe you me, when we get the next opportunity to try to get back that presidential primary, we will. But right now, we're stuck. And we think this is the best thing we can do for access right now. It's what our party has stood for. And the Republicans, you know, are doing just the opposite. They're trying to make it harder to vote, more restrictive to vote. And so this is our attempt to make this work the best that we can. We modeled this after other plans that we understand have been approved through the DNC. And so I know you all have the detail of the plan. We're actively raising money for this. We know party run, it means party expense. You all may have heard we're doing some great work fundraising in Missouri. We had a sellout crowd at our Truman dinner this Wednesday night. I had to turn people away. That was a great problem to have, but we think people are investing in the work that we're doing, and this is a good example of that. So with that, I want to leave time for any questions. And again, I'm sorry our chair, our committee couldn't be here. He had to be out of state. We also had representatives from organized labor that were going to present on, you know, the impact on working people, going to the caucus only, and they also couldn't be here with this late time in the meeting. But so I hope that gives you a good overview of what we're trying to do, again, to make the best of a bad situation. And frankly, we think there's a organizing opportunity to do this outreach, and I feel like that's our obligation as a party to make this as accessible as we can.
Thank you. Do any of the committee members have any questions for the panel? Yes, Ms. Kmark.
Nice to see you here. Thank you for having us in St. Louis. The decision to do this is, of course, exactly the right decision. And even though this committee has discouraged caucus systems for some time now, we obviously had to leave open this option for situations exactly like this. Donald Trump, as you know, got rid of a lot of Republican primaries in 2020, and I'm sure he wants to keep it that way and is working hard to create a system that will make sure he has no opponents. So this is not your fault, and we totally understand that. One thing I'm curious about, though, is you said this is going to be hybrid. I understand a mail-in ballot, but you're also going to have caucus meetings?
Yes.
Okay, so how are you going to count the votes? I mean, you got two different vote things. Presumably there'll be reporters there, say, here in St. Louis, reporting on the caucus meetings, but if the ballots come in and change the outcome of the caucus, you know, we have these situations we've been trying to avoid since 2020 where the voters think something funny is going on just because two sets of votes are reported at two different times. It's not really, as we know from 2020, it was just that the red vote came in first and the blue vote came in second in the mail-in ballots. But frankly, that causes a lot of suspicion, and we're very prone in this country to disinformation and conspiracy theories. So my question to you is, how are you going to deal with that issue if you're having an in-person caucus and mail-in ballots?
Well, you raised a great point, and I should have mentioned it earlier, but there's an extensive education component to this. While some of this will seem familiar to Missouri voters, some will be a little bit different. So again, that's an obligation of the party to explain that. But by having the mail-in prior to the in-person meeting, then after both of those are done, then they'll be combined and the vote announced.
But will the mail-in be announced at the time of the in-person meeting?
No, those votes will have to be combined and tabulated, and once that's done, then there'll be a combined vote announced.
So, all right, so this is going to be your problem, right? There will be press people and people who come and watch the in-person meeting. And the in-person meeting is going to show, I don't know, 10 for Marianne Williamson and 90 for Joe Biden, okay? When the next day, or whenever you announce the full thing, right, you're going to have a lot more for Joe Biden. How, you know, I think education, frankly, we always say that, but frankly, it never works, okay? There's people who, this system is just prone to conspiracy. Is there a way that you could do the announcement at the same time on caucus night, announce the ones that came in by mail?
Again, I'm not an expert on this, but my understanding is they have to be combined and tabulated and then announced. So I don't think there will be any real practical way to make an announcement the night of those individual meetings.
My suggestion is you got to think about this because, you know, there's a lot of conspiracy theories out there, and this is exactly what leads into those conspiracy theories. Now, this year it may not be a big deal. We have a sitting president. Obviously, we hope to, you know, nominate him overwhelmingly. But imagine if you had a contest. This could be quite a mess.
Yeah, I'm going to let our executive director address part of that as well.
Thank you. To address your question, so at the mass meetings, there will be, and we're going to work with a vendor, so those ballots will go into secure voting. You know, people will vote the ballot, put it in the machine, and those machines are secured, and they will deliver those ballots to a central location in probably Jefferson City, Columbia, where we can find space to have it and count them, and be using a vendor on that. So in terms of any kind of security problems, the ballots will be secured, and there will be no opportunity, to question that, because that process, will be entailed with that.
Oh, so you will not announce the results of the in-person caucus on the night of the caucus?
No, ma'am. Those will be ballots that'll be put into
all
a
right.
machine, and so that's, yeah.
Sorry, I missed.
Oh, that's okay.
My
Yeah.
apology, I missed that. Okay,
But yeah,
great.
to let you know that will not be a problem, and that when we put all the ballots together and those are tabulated, then we can announce.
Right.
Announce
I
the
mean,
results.
you still could have a little bit of a problem because people will go and count the number of people in the room.
Well, that's true. Yeah.
Right, but as long as you're not announcing it, and in the not announcing, you are saying this is only a partial result for this county or this precinct, however you're going to do it. I think that's fine. I'm just saying beware, because this is going to be an ongoing problem.
Oh, yes, ma'am. Yeah. Thank you.
Councilman, can I ask just one quick question? What do you all believe the awareness level is of it being changed from a primary to a caucus?
That's a great question. If you stop 10 people on the street in St. Louis, 9 out of 10 would tell you we have a presidential primary. And the awareness level is very low. So again, it's going to require an important education component, outreach, using our democratic networks, using our allied organizations to get that word out. Again, we're trying to turn this challenge into an opportunity for messaging, for organizing, and to make the most of this.
Ken?
Oh. Thank you. Just wanted to follow up and to make sure it's clear. So the caucus is really just sort of a firehouse primary where you just go and you turn in your ballot and you leave. It's not where you organize different groups. And then the mail-in votes, are those added to each of the county totals?
Right.
Okay. All right. Thank you.
Thank you, Mr. Chair, and I want to thank Chairman Carnahan and the whole team here for their wonderful presentation. I just want to a special thanks to Russ for his work. He just was elected into this position, came in and has been doing a just great job of really convening all sorts of stakeholders around this state in this rebuilding process, and of course hosting us here in addition to this sort of scramble to have to put together a plan. I really think that they've done a wonderful job, and I actually want to make a motion that we pass this in full compliance today, conditional compliance.
Motion is not in order yet because we'll hear the staff report and so on, but we'll
I forgot about
return
that.
to you on that. Any further questions for the representatives from Missouri? Yes, Ms. Brazil.
Thank you, Mr. Chairman, and thank you, Madam Mayor, and other statewide leaders for putting this together. I recognize the urgency that you had to make this plan possible. I just have a basic question. I've asked several states, and putting forward your diversity goals, your outreach and inclusion goals, I noticed that there was a small dip in the percentage or the outreach toward African Americans, and there was basically status quo or no improvement or expansion of Hispanic Americans and others. So can you just give me a quick overview of how you come by those numbers, and whether or not in trying to reach these goals, will you be able to ensure the broad participation that we seek in our political party?
Yeah, no, thank you for raising that. That's been a very high priority for us because we see that diversity and those allies around our state as key to our rebuilding. We've seen that not just in minority populations, but youth populations. We have an extraordinarily large percentage of young voters in our state. So just they're great opportunities for us. And so my understanding those numbers are based on the numbers and guidance we got from the DNC, and that we've reflected that. But our goal all the way along is going to be to not just meet but exceed those. I think we look at those as sort of a base, not a ceiling.
Well, I recognize you might have got it from the home base, but sometimes when it looks like it's off-centered, you have to question it. Because unless I've missed the last 3 or 4 years, and I don't think so, I have seen a strong indication that we are growing as a country. We are expanding as a country. We are more diverse today than ever before. And I just want to make sure that these goals reflect who we are and, more importantly, what the Democratic Party stands for. So I appreciate that you got it, but I am also worried, and I'm going to continue to express my concern, because we worked hard to expand the participation of everyone in this political process, especially those who've been underrepresented or those who have faced historic barriers to participation. But we also want to make sure that that door is wide open so every American know that they have a home and a seat in our political party. Thank you.
Thank you.
Any other questions? Yes, Carol, and then Frank.
Thank you. I want to say I know you're in a tough position, and I don't disagree at all with what you're planning to do to solve this tough situation. But you have said that the people are expecting a primary, and they don't expect or understand caucuses. And then you've said that this is like a firehouse primary. It's a primary, but with limited voting hours. Why are you calling it a caucus instead of a primary?
Well, frankly, we've kind of used those terms interchangeably. We've called it a party-run hybrid primary, and when we've talked about it, we've made a special point to say, that there's a in-person and vote by mail option during the process. And so you're making my point exactly. There's going to be a lot of education involved, but we just want people to know they have that option, and we're going to do the very best we can to make this process accessible, because frankly, for the credibility of our democracy and our elections, if we have a caucus only and fewer than 1% of the people show up and participate, that's really bad.
That is really bad, and so
our party.
Why not just call it a primary? If every time you say caucus, somebody gets confused and decides to stay home, why ever use the confusing word?
If I could jump in, excuse me, Carol, and Mr. Carnahan, I really agree that when you say caucus, there are people who say, well, I'm not doing that. I don't know what it is. I don't have a day. I don't have all evening, and so on. When we talk about it technically, it's a caucus. But using the term primary, I don't see it has any downside for you. It lets people know what they're doing. So let me just say.
No, I like it. That's a great suggestion.
Yeah, see, Carol's point is well taken. That's why I was confused. I was thinking you were going to have a classic caucus, and people would be able to see who was voting for who, and then we were going to have this other man.
Not that.
I would drop the term caucus.
And Elaine, if you were confused, what about the average voter?
That's a good point. That's a good point. So if you're going to use this, call it a party-run primary. That's what it is. We have lots of those. Your voters will know that it's going to be slightly different than a state-run primary, probably in the polling locations. But you're right, you have a party-run primary. You don't have a caucus. Caucus is where people go and they stand around for a couple of hours and they do business, et cetera. It has its virtues. I don't want to dump completely on caucus, but not in the presidential realm in this day and age. So I would just suggest you save yourself a lot of grief if you just stop calling it a caucus.
No, great suggestion. Thank
I'm
you.
glad we got into this discussion. All right. Any other, Mr. Leon?
Yeah, thanks. I appreciate the predicament you guys are in and your efforts to try to do this. I'm curious about the ranked choice voting aspect of it. That's not something that you all have done before, presumably.
It is not. And again, our committee, chaired by Gunnar Johansson, really dug into this, looking at other state models and options. And that's how we came up with this. And looking at other states that have done this successfully, whose plans have been approved, that's what we tried to take the best of that and apply it to our situation in this plan.
And St. Louis has approval voting, but
Right.
that's different than
It
ranked
is.
choice. Yeah. Okay. Thank you.
Okay. Any other questions from the committee? Well, thank you for joining us today. We will return to our discussion and our vote on the plan, but this was very helpful.
No, thank you all. Thanks to the full committee, and thanks for accommodating the time for the mayor to join us. Thanks so much.
Okay, thank you.
So we're getting ready to start the delegate selection process status update. Before we review new plans, we'd like to take stock of where we will give. Thank you all so much for joining us. We'd like to take stock of where we currently are in the delegate selection plan review process. As a reminder, per Regulation 2.7b, plans found in conditional compliance must correct the omissions and the deficiencies provided to them within the staff evaluation within 30 days of receipt of notice of the RBC's finding of conditional compliance. Sometimes this process takes more or less time, and the Party Affairs Department works closely with the states to achieve full compliance for their plans. Once a state party has taken appropriate corrective action in response to each of the items of omission or deficiency, their plan is automatically found in compliance. 33 states have been found in conditional compliance to date. The Party Affairs team has recommended that 18 plans be found in full compliance, inclusive of 8 states that we shared with you at our meeting in September. They are America Samoa, Arkansas, Delaware, Florida, Illinois, Kentucky, Maryland, Massachusetts, Michigan, Montana, Nebraska, North Carolina, Ohio, Oregon, South Dakota, Vermont, Virginia, Wisconsin. Party Affairs continues to work with the other states found in conditional compliance to reach full compliance. The department has also been working closely with the Iowa Democratic Party on the timing of the presidential preference contest and the requested additional logistical information needed in their plan. I'd now like to ask Scott Brennan to provide an update to the committee. Thank you, Scott.
Thank you. It might just be most clarifying if I went ahead and just read a letter that my chair has submitted, if that's acceptable. Dear committee co-chairs and members, I'm thankful to this committee for giving Iowa an extension to refine our delegate selection plan. I would like to provide additional comments and context regarding the updates we've made. As you know, Iowa Democrats have listened to the concerns of this committee and have worked tirelessly for nearly 2 years to create the most inclusive presidential nominating process in history. Building upon the good work of my predecessor, Representative Ross Wilburn, our reimagined Iowa caucuses will be composed of 2 parts, a mail-in expression of presidential preference and our in-person precinct caucuses. After negotiations with DNC staff, we will update the following information in our delegate selection plan. Iowa Democrats will be able to register for our mail-in process starting November 1, 2023. Presidential preference cards will be mailed starting January 12, 2024. Iowa Democrats will hold our in-person precinct caucuses January 15, 2024. The last day to request a presidential preference card is February 19, 2024. The Iowa Democratic Party will release results of our 2024 mail-in caucus presidential preference on March 5, 2024. Iowa Democrats will accept presidential preference cards postmarked on or before March 5, 2024. I am pleased to have repeated reassurance from the co-chairs in this committee that the presidential nominating calendar discussions will once again be opened up for 2028, where I expect Iowa to compete strongly for a significant voice in the selection of the Democratic nominee, as we have for years. As a resident of the small town of Wheatland, Iowa, it is vital small rural states in the heart of the Midwest have a voice in this process. Democrats need our diversifying rural communities to ensure future electoral victories. We believe this delegate selection plan is a compromise and meets the requirements set forth by this committee, complies with Iowa law, and most importantly, sets Iowa Democrats up to win in 2024. Republicans continue to attack our inclusive Iowa caucuses and have conspired to meddle in our party business. Despite their empty rhetoric, I've always said I will do what's best for Iowa. Historically, North Carolina, South Carolina, Tennessee, Michigan, California, and other states have at one time or another begun their processes before any authorized caucus or primary state in the pre-window. To blame Democrats for chaos in the Republican calendar is unfair, misguided, and just plain wrong. We will continue to work cooperatively with Rules and Bylaws Committee staff to satisfy any remaining outstanding logistical issues regarding our delegate selection plan. And with that, my personal thanks to you all, the members of this committee, to the staff, and to our co-chairs for working with Iowa through a long and very difficult process. With that, I would move that Iowa be found in conditional compliance.
Second.
Thank you, Scott. Before we move on the motion to move Iowa to conditional compliance, I'd like to take a moment of personal privilege. These have been lengthy and vigorous negotiations, and I'd like to commend Scott, the Iowa Democratic Party, for transforming their caucuses to include an inclusive and accessible mail-in process. This work began under former Chairman Ross Wilburn and continued under the leadership of Chair Rita Hart, who both understand that we need to make it easier, not harder, for our fellow citizens to engage in our democracy. We're looking forward to supporting them through this process and addressing the logistical questions raised in the staff evaluation. Is there a second to Scott's motion? We have a motion and a second. The floor is open for discussion by the members. Yes.
Thank you, Madam Chair. And yes, I appreciate the work that Iowa has taken on and the team here, the staff working with him through this process, with Iowa, State Democratic Party in this process. When will we see, so we're going to approve the conditional compliance. When can we anticipate to see this new process in writing and language?
Someday.
Sunday?
We're still working on that. I think, Obviously, there's been some staff issues we need to work through, but we have committed to coordinating with the RBC staff, and I'm confident we'll have something before you all fairly soon.
And the staff has been working very collaboratively with them. Any further discussion? The chair will ask for a vote on the motion to move Iowa's plan to conditional compliance. All in favor of the motion, say aye. Aye. Those opposed, say nay. Somebody in the background says the ayes have it. Thank you. This is a great step forward for ensuring a strong voice for Iowa voters in 2024. And as we've stated previously, we intend to review the presidential nominating calendar again for 2028, so we look forward to hearing from Iowa again in that process. We've now discussed plans that are in full compliance and the process for those in conditional compliance. To complete our overview, a reminder that plans that are found non-compliant must be corrected and resubmitted within 30 days. In reviewing submitted plans in non-compliance, the RBC may grant waivers, impose sanctions, or take the types of corrective action contemplated in Rule 21.c. I'd like to ask Elaine to speak a little bit about the history of sanctions in this process.
Thank you. For some of you, this will be old history. For some of you, it will be new history. And I just want to go back to August 25th, 2007, when this committee voted to strip Michigan and Florida of 100% of their delegates to the convention. All members of this committee voted on that. It was a unanimous vote, as some of you will remember. By the way, the RNC had already done something similar to states that were trying to move ahead of the window. They had stripped a bunch of states of their delegates too. And the reason was, of course, that this was turning into, in 2008, this was turning into a disaster. States were jumping ahead, and it looked like we were going to have a New Hampshire primary at Christmas or Thanksgiving, and we knew very well that the voters would be really not pleased with us for doing that. So everyone cheered when the Rules and Bylaws Committee said, no, Michigan, no, New Hampshire, Florida, you can't do this. At that point, our distinguished colleague here, Carol Fowler, circulated a letter to all the presidential candidates, and I want you to pay attention to this because this goes to sanctions, asking them to pledge not to campaign in any of the early states that were not approved by the Rules and Bylaws Committee. They all signed this letter. This was October of 2007. All the presidential candidates signed that letter. Subsequent to that, Barack Obama, Joe Biden, John Edwards, Bill Richardson, and Dennis Kucinich took their names off the Michigan ballot. Again, they took their names off the Michigan ballot, leaving only Hillary Clinton and Chris Dodd on the Michigan ballot. In Florida, the system there was no option for getting your name off the ballot, so all of the candidates remained on the ballot. And then the race started, and Hillary Clinton and Barack Obama found themselves neck and neck in terms of the delegate count. They were only about 100 delegates away. That's not very many out of 4,000 or so delegates. And so everybody was looking for a way to finish this race. And Hillary Clinton brought a motion to the Rules Committee on May 22nd of 2008, asking this committee to seat the delegates of Michigan and Florida, thereby retroactively undoing what this committee had done 8-9 months earlier and changing the rules. That would have given Hillary more delegates, although not quite enough to top Obama. But what it would have given her was the vote totals. As you can imagine, this was really hotly contested, and some of us were there and can remember the 9 hours of meetings. But what was at stake really were the national vote totals. The Obama campaign was rightly incensed because they were not on the Michigan ballot. Uncommitted had gotten 44% of the Michigan ballot, so Hillary's campaign was arguing that they would get that proportion of delegates. In any event, what happened was the committee voted to sustain its prior ruling and not seat any delegates from Florida and Michigan. It was very important in the broad sweep of the history of the Democratic Party, because what happened there was people said, we are going to make rules and we are not going to change them according to the ups and downs of the presidential campaign, and that our rule was going to be final. The people who voted here, myself included, Don Fowler also, Carol, were you on the committee then? Yeah, Carol. The people who voted, we are what us political scientists call institutionalists. We put the institution of the party ahead of our individual politics. And some of us were Hillary Clinton supporters. I know I was, and Don Fowler was. And we voted against her in that committee because to reverse this would have been to say that this committee is not a serious place. It's not serious about what it does. So that's number one. I want us all to understand what being an institutionalist means in terms of the party. Secondly, though, is that our sanctions are pretty weak, okay? Let's face it. I mean, we don't sit the delegates. Big deal. New Hampshire never cared very much about seating its 20-some delegates. They cared about their first-in-the-nation primary, and I understand that. The only option there was to require a state to have an alternative system. Missouri is doing that, okay, because they can't have their primary, and other states have done that. So that's about all we can do. However, what is the ultimate sanction? The ultimate sanction is that the presidential candidates don't go there. In other words, if you have a primary and nobody goes, you might as well not have a primary. And that is really something that we need to think about. I think reporters are always asking, oh, what are you going to do about this? What are you going to do about this? And I say, we're doing nothing about this. Okay? We've made our decision about the sequence of these early states, and we're going to stick to that sequence. And the next question is, will the candidates go? In 2024, I'm pretty sure that Joe Biden will not put his name on the New Hampshire primary ballot. Okay, if he did, this would look really weird since he was the one who said he wanted to have South Carolina first. But there are informal political mechanisms that work actually really well. And Carol, bless her heart, kind of invented them. I can imagine that politicians from South Carolina, from Nevada, from other states, will issue similar letters to presidential candidates in 2028 saying, please don't put your name on the ballot of any state that is running prior to the states agreed upon by the Democratic National Committee. And we'll go through this process again, so I can't say who those states will be. But in other words, we have our party sanctions. They can work, although they're not, terribly, they don't really sway many people in states that are used to having an early contest. But we also have our sway over presidential candidates in our party, and the sanctioned early states have a great deal to say about people who are trying to jump the gun. This is all very dear to me in this day and age as we watch the House of Representatives deteriorate, okay? by a group of people who are not institutionalists, who by and large don't give a you-know-what about what happens in the House. We can't do that for the Democratic Party. We have to set our rules, believe in our rules, and stick by our rules. Thank you.
Thank you so much, Elaine. Do any of the members have any questions for Elaine? Yes, Mo.
Thanks, and it's less of a question and more just to underscore something that Elaine was just talking about, and something you said at a previous meeting when we actually voted on the framework for this cycle. And I think this is important for anyone watching to remember, and that is the enforcement mechanism for candidates, which this committee adopted, is a game changer in many ways. As I sit here and listen to you walk through the history of sanctions, the fact that this committee chose to hold candidates as accountable as states is absolutely critical. And I also get a lot of calls from members of the press asking, why does any of this matter? It matters because candidates now are going to be held just as accountable. And I think that was a huge step forward for this committee that sort of follows along that evolution of enforcement that you walked us through so beautifully. And this has real teeth, what this committee has done. I'm proud of that, and I think it will provide that sort of institutional protection that you're right, we so need. So I just want everyone to reflect on that.
Mm-hmm. Thank you, Mo. Any further discussion or questions? Seeing none, we'll now move on to the review of delegate selection plans. We'll begin with states with party-run processes that include ranked choice voting. Jim?
So at our previous meeting, we reviewed the plans for Hawaii, Alaska, Wyoming, and Maine. We found each plan to be in conditional compliance. One condition of those findings was that each state must work with party affairs to ensure their system complies with our rules and then return to this committee for further consideration. We provided you with an update of this work at our meeting in September, and you will find additional information provided by the states in your folders. Anytime a new factor is introduced in the delegate selection process, we need to critically examine it. Ranked choice voting is no different. Our job is to ensure that the rules are applied to all delegate selection processes, but in a manner that is fair, transparent, and accessible for voters. I thank our DNC staff for reviewing these plans with those goals in mind. The ranked choice voting provisions in Maine's plan involve a state-run primary, while the plans for Hawaii, Alaska, and Wyoming involve party-run processes. Both systems require closer examination to ensure compliance with our 15% viability threshold. Because there are differences between the party-run and state-run processes, our discussion is best divided into two parts. We'll first discuss our recommendations for the party-run processes of Wyoming, Alaska, and Hawaii, hear your thoughts, and put forward a motion to offer further direction for DNC staff as they continue their work with these parties. After concluding that discussion, we will discuss Maine, where we will provide our recommendation and facilitate member discussion. Before we discuss either process, I first want to review the key tenets of Rule 14 and the viability threshold. Rule 14 addresses the fair reflection of presidential preference. It requires that states allocate delegates and alternates in proportion to the percentage of the primary vote won by each preference. And importantly, Rule 14 states that preferences falling below the 15% threshold shall not be awarded any delegates. While Rule 14 is clear that only preferences that receive at least 15% of the vote will receive delegates, during our July and September meetings, many voiced concern about the prospect of candidates failing to reach 15% on the first round of votes and attaining viability on a later round. The DNC staff took that concern into account when meeting with state parties and outlining solutions. How the 15% threshold is interpreted and applied will be at the center of the discussion we're about to have. Mignon?
Thank you. Sorry about that.
That's all right.
So beginning with the Party 1 process of Wyoming, Alaska, and Hawaii, these plans outline a process in which only the lowest ranked candidate is eliminated and their votes are added to the voter's next choice. This results in a process where candidates who are well below the viability threshold in the first round could achieve viability by accumulating votes of previously eliminated candidates in later rounds of counting. The staff met with these state parties and shared the committee's concerns about how the ranked choice voting process fits within the application of our delegate selection rules. Based on the meetings with state parties and the staff's suggestion, Mignon and I recommend, which is not true, Jim and I recommend that the states,
A little last minute editing.
yes, yes, that the states adopt provisions in their plans to eliminate all candidates who do not meet the 15% threshold on the first round simultaneously and reallocate their votes only to viable candidates. Additionally, we recommend that state parties implement robust voter education programs directly addressing ranked choice voting. State parties should develop those programs in consultation with the DNC party affairs and voter protection staff. In order to open discussion, I'll entertain a motion to allow party-run processes that we have conditionally approved, like those in Hawaii, Alaska, and Wyoming, to incorporate ranked choice voting in their processes in a manner by which all candidates receiving less than 15% on the first round have their voters' preference reallocated simultaneously. States must also conduct strong voter education efforts. Staff has drafted this recommendation for inclusion and staff evaluation to these states, as you can see on the screen. So I have a motion, do we have, okay. We have a motion and a second. The floor is open for discussion by members. Oh, David, huh? David,
sorry.
David.
Because of, I'm just waiting. I know that applause is not for me. I don't want to have an extended discussion. We've talked about this many, many times. All I really want to do is note two things. One, I think the question of the 15% threshold and Rule 14 depends upon what we decide is the final vote in these processes, and historically it's not necessarily the first vote that is cast in a multi-round process. However, we are now at the end of the review session. We need to give people some way to go forward, and we've already decided that we're going to have a comprehensive discussion about ranked choice voting and what guardrails should be in place and so on at some point in the future after this. So I don't intend to oppose this, but I do want to note for the record, we are not deciding today what the rules of RCV are going to be in future plans. We're just dealing with the reality that this is coming up at the tail end of the session. And certainly there are many voices on this committee who think that exactly what is being recommended here is where we will end up, but the question's not being decided. And with that, I don't want to delay anybody else's day, so let me end.
Thank you. Frank?
I second David, and also I don't think this should be interpreted as even indicating that we would permit ranked choice voting in subsequent cycles. We're going to take a hard look at all of this going forward, but this is a quite reasonable approach to where we are now.
Thank you. Any further discussion? Jim?
So I would just add along the lines of what was just said, that it's important to keep in mind that in each of these states, we evaluated whether they had the capacity to do it. It wasn't ranked choice voting just as a matter of right. We looked at, did they have the financial and administrative capacity to administer it?
Do I say? Go ahead, Luis.
Madam Chair, I have to echo what Frank in making sure that this action or statement does not get misinterpreted. But I also ask if I know proponents of ranked choice voting are trying to see if party apparatus for validation or for us to use it in this primary process. And transparency matters if there is also the incentives of paying for primaries or other issues, that we could keep an honest conversation among this committee and the DNC and those groups that are proposing to finance, just to use this validation for future conversations. It is something that I just need to raise the transparency flag, because the proponents of this type of reform are also looking for, news stories and validation through the party apparatus.
Mm-hmm. Thank you. Any further comments? Seeing no further discussion, the chair will ask for a vote on the motion to allow Hawaii, Alaska, and Wyoming to incorporate ranked choice voting in their processes, subject to the reallocation and voter education requirements. All in favor of the motion say aye. Aye. Those opposed say nay. The ayes have it. Thank you. Jim?
So now, moving on to the state of Maine, Maine worked with DNC staff.
Your mic, Jim.
Maine worked with DNC staff and provided helpful information and insights. They too have thoroughly responded to the committee's request for additional information and have engaged in many productive conversations with our staff. We also appreciate the opportunity that we did have at our last meeting to hear from Maine Secretary of State Sheena Bellows and Wayne Kinney from the Maine Democratic Party, who discussed the use of ranked choice voting in their state up to this point. Mignon and I, and it is Mignon and I, would like to recommend that we allow Maine's tabulation to proceed as designed by state law, but only for this 2024 cycle. We're not expressing an opinion on whether it will meet our rules for 2028. Ultimately, our job as a committee is to ensure that party rules are recognized and respected, but we also do so while ensuring that any Democrat can participate in a way that is transparent, consistent, and predictable. Allowing for the Maine Democratic Party to use the state's tabulation would provide consistency for Maine's voters, who have engaged in and have supported this form of voting for some time. It will also allow us a platform to work closely with the party in advance of 2028 to make sure their process works directly in line with our rules. This determination would be solely for the 2024 cycle and would not carry over into 2028. It would be with the explicit directive that the party ensure the state's tabulation process allow for the boundaries set forth in our rules before 2028, or the party must consider alternative processes. Alongside our recommendation, we will ask that DNC staff communicate to party officials that they must commit to working on this issue for 2028, and that if it is not resolved, the committee may require the Maine Democratic Party to explore implementing other processes. We would strongly prefer that Maine work with us to develop a state-run process in line with our interpretation of Rule 14's threshold. If the system is not corrected for 2028, Maine could run the risk of infringement upon Rule 14G next cycle, rendering their state-run contest a straw poll contest, which presidential candidates would not be able to participate in. So I think what I just said falls into the category of tell them what you're saying, say it again, and then say it again to make sure they heard you. Taking all of that into consideration, we'd now entertain a motion to allow a waiver to our interpretation of the 15% threshold described in Rule 14, allowing for Maine to proceed with the state-run primaries tabulation results. The motion would be contingent upon the state party and Democratic officials committing to working with the DNC to resolve this issue before 2028, or run the risk of penalties and alternative processes in 2028 if they're unable to resolve the discrepancies to the satisfaction of this committee. Is there a motion? And a second? Thank you. Okay, so we have a motion and a second to grant with conditions this waiver to Maine. The floor is open for discussion by members, and I'll call on Mr. Leone.
I know you're just going to agree with what I say, Frank.
Mr. McDonald.
I just want to emphasize that, and this is embedded in what you're saying, state legislatures that are being asked to consider bills in incorporating ranked choice voting for presidential primaries now, because there is lobbying going on, should not copy Maine's statute on the assumption that Maine has solved the riddle and that the DNC has blessed the Maine interpretation or application, or for that matter, that the DNC has blessed any statutory framework for using ranked choice voting. I have seen in my jurisdiction resolutions circulated that certainly strongly suggest that the DNC has approved certain models are okay, and that is simply not the case. Frank and I are in agreement that A, the thing is going to be discussed, and B, we have not landed on anything, including, as Frank has said earlier, whether future rules will permit the use of ranked choice voting. Currently, we're open on it, we're going to discuss it, and that'll happen. But nobody should think that there's any guidance for how to do it in the Maine proposition. Taken as a whole, they have done some things that are very workable if you're going to do it, but that's the end of the discussion. So.
Mr. Leone?
Yeah, I agree with everything Mr. McDonald said.
We'll now take a short no, I'm sorry.
And I think the point is the Maine statute is written, and we've talked about this at length before, basically is inconsistent with our proportional representation system and our 15% threshold. And they have a workaround this time, but as states look at implementing ranked choice voting, you know, the Secretary of State in Maine said the law is neutral as to the parties. And I get that, but from the party perspective, it's got to be compliant with our rules. Thank you.
So what we're saying, and then saying we mean it, is it's not a model. It's something that can work as an exception. Any further discussion? Carol.
I just have a question. It might be that ranked choice voting is just too hard for me, but tell me what the main results will look like. I mean, when the Secretary of State talked to us, she said what they do is keep refiguring until somebody has 50% plus one. So will the final result be winner take all? Will it be, I mean, tell me how these results will be reported. It's just too hard for me.
So we have a representative here from Voter Protection who perhaps can explain this.
Yeah.
Would you introduce yourself, please?
Hi, I'm Jake Hensel. I'm the Deputy Director of Voter Protection at the DNC. So the way that the Maine results will look is that they're going to publish each round of tabulations. So we would see the first round and just everyone's initial votes, and then we would see the bottom candidate eliminated and their votes transferred upwards. And so we would see every single round until they got to that final round with just two candidates. But what the party would do is take whichever round has the candidates, has everyone above 15% and no candidates below 15%, but not any subsequent round. So the state will publish all rounds, and that will be visible, including rounds that are that continue after our tabulation that go further than we would consider.
So,
Microphone, please. Microphone, Carol.
There. I mean, if candidates see what might have been or what is now because of this, is this going to be upsetting to our presidential candidates? Or, you know, it just seems like we're unleashing some craziness here.
I'm not sure that's a question that we know the answer to. I think we can say this is fair and equitable to all of them, to any candidates, but whether some will be unhappy with it, we just can't answer it. Yes, Artie.
Yes, thank you, Mr. Chair. But that's the action we're taking today is to say we're okay with it now. We've got our president running for re-election. But this is definitely something but we do not approve this process for next time until we've had the time to dive in for the 28th cycle. Is that correct? Like, we're only approving for now. I think these are valid questions that Ms. Fowler is bringing to us about what, you know, how candidates may react. So I understand that. It is very confusing, and I agree with what we're doing just to get through this time, and I think we should vote.
Any other questions or comments? So we have a motion and a second. And seeing no further discussion on that motion, I'm going to ask for a vote to allow a waiver to our interpretation of the 15% threshold described in Rule 14 with the conditions as discussed. All those in favor, please signify by saying aye.
Aye.
Opposed, no. No. The ayes clearly have it, but we will record that it was not unanimous. Okay.
So that brings us to our new state plans. As you will remember from our meetings this summer, your folders contained a summary of findings, 4-page synopsis, and staff evaluation for each state. The staff evaluations were preliminarily shared with state parties so that the staff may reference responses from the states in their presentations, but the PADS office has not processed new submissions in their entirety yet. For each state, we'll ask a PADS team member to present their findings and recommendation. If a representative is here from the state, they will be asked to speak as well. Following the presentations, we will call for a motion regarding the plan's compliance. This will allow for discussion to begin. Once discussion is complete, we will vote on the plan's compliance before proceeding to the next state. Jim?
So the first new plan that we'll consider today comes from our host state, Missouri, where we already heard a presentation from the state party. It was a very persuasive presentation, also, so much so that we almost didn't have this presentation. But the Missouri legislature, as we heard, eliminated their state-run presidential primary. Legislators attempted to reinstate the primary this spring, but the Republican leadership stopped that from happening. Those legislative changes delayed Missouri's drafting and submission of their plan, but it now includes a party-run process. I'm going to recognize John Mott to give us an overview of the plan.
Good afternoon. Missouri will determine presidential preference through a party-run presidential primary utilizing ranked choice voting on March 23rd. The primary will include in-person voting and a vote-by-mail option. 42 district-level delegates are elected by congressional district caucuses on May 9th. 8 PLEO delegates will be elected by the State Democratic Committee on May 18th. 14 at-large delegates will be elected at the state convention on June 22nd. Missouri's representation goals are aligned with the suggested goals provided by the DNC data and analytics team. The plan incorporates the use of ranked choice voting for purposes of determining presidential preference. Staff has not received sufficient information to allow us to say that they have the technical or financial ability to execute ranked choice voting as required by Rule 2K2 of the delegate selection rules. Should this committee decide, as it did in July, that states that have not previously implemented ranked choice voting in their plans, we will update our staff evaluation to include the removal of ranked choice voting for the purpose of determining presidential preference. I do want to note that because of the delays in getting the plan drafted and posted and in, they got it, the state party got it in. We reviewed it, sent them back a staff evaluation. They responded and took care of almost all of the issues that were in the staff evaluation. So I just note that so that if you're looking through your packet and looking at the staff evaluation, most of the items that are in that evaluation have already been taken care of. With that, the plan complies with the spirit and generally the substance of the rules, call, and regulations, but has certain deficiencies. Staff recommends that the plan be found in conditional compliance, inclusive of the removal of ranked choice voting from their plan, pending the receipt of requested information.
Thank you, John. As I mentioned, we have heard the presentation from the chair of the Missouri Democratic Party. Is there a motion to find the plan in conditional compliance? I think Mr. Martin's offering that motion. Is there a second? There's a second. Any further discussion? Frank.
So that motion carries with it that we're not approving the ranked choice voting part of it?
That's correct.
That is correct.
Okay, thank you.
So, any further discussion? And I'll just point out that not approving the ranked choice voting part of it is in compliance with our previous discussion. This is not a ranked choice voting process that has behind it experience of doing it in the past and or a demonstration of the financial capacity to carry that out. Any further discussion? All right, seeing no further discussion, we'll go to a vote on the motion. All those in favor, please say aye.
Aye.
Opposed, nay. And that does carry unanimously.
So the next plan we'll take up is from New Hampshire. I'll recognize Veronica to give us an overview.
Great. Thank you, Mignon.
The delegate selection plan for New Hampshire provides for delegates and alternates to be allocated proportionally to presidential preference based on a presidential preference primary on a date that has not yet been set. As you all know, that date will be selected by the New Hampshire Secretary of State, Secretary Scanlon, in accordance with their state statutes. New Hampshire does a pre-primary caucus process to select their delegates. So their district-level delegates will be elected at a pre-primary caucus on a date that is not indicated in their plan, but it's indicated as 17 days before the primary. The quorum of district-level delegates will select the PLEO delegates, at-large delegates, and alternates on April 27th. New Hampshire is also afforded for electing additional district-level delegates if needed on April 27th if there were not sufficient district-level candidates at the pre-primary caucus, and a presidential candidate receives more of the allocation than based on how many district-level delegates were elected. The delegation will select the standing committee members and the chair on April 27th as well, and along with the convention pages. New Hampshire has responded to our staff evaluation. They've done a great job of covering a lot of the items we listed in the staff evaluation. I am still working through that, and so need to finish navigating that, but did want to acknowledge them sending that. They also added a waiver, requesting a waiver to 12B and 15D regarding the timing of their filing period. Their filing period is currently October 11th to October 27th. Given that they don't have the date of the primary, they're not sure how that filing period infringes upon Rules 12B and 15D, and that's why they're requesting the waiver. The staff does recommend that this plan be found in noncompliance. We recommend this because the plan violates timing as defined in Rule 21C1 by providing or permitting for the first determining step to be held prior to the window set forth in Rule 12. As no date has been set, so it creates a situation where it provides or permits for that opportunity. But we look forward to continuing to work with the New Hampshire Party. If a plan is found in noncompliance, we do ask that it is returned within 30 days in a compliant state, and we look forward to continuing to work with the New Hampshire Democratic Party on that, and I believe we have representatives from the state here as well.
Is Ray Buckley in the room?
Yes,
Thank
he
you, Ray.
is.
Ray Buckley, Chair of New Hampshire Democratic Party.
I assume this is on? Can you hear me?
Yes.
Okay. Good morning. Thank you, Madam Co-Chair, Mr. Co-Chair, and members of the committee. For the record, I'm Ray Buckley, the chair of the New Hampshire Democratic Party. I have with me our former Senate President, our current Senate Democratic leader, and Democratic National Committee woman and member of the Senate Election Law Committee, Donna Susie, and our Executive Director, Jack Tremelin, our former Data Director for many years. I can take questions if that would be preferable. We obviously are at the whim of the Secretary of State, not to change the subject, but the Secretary of State did appear to make a statement a few moments ago saying that the Iowa proposal, as articulated today, did not require him to bump ahead of the Iowa. So the chaos that would have even been created further appears to have been averted. So that's a positive step there. We do not know when the Secretary of State plans on making that decision. He could make the decision up until the beginning of December. He could wait. We just simply need 45 days to conduct the primary. What we're trying to do is continue the system that we've essentially been operating under since 1980, when we changed the entire process and no longer elected delegates on the ballot. That's why we wish to continue to do a pre-primary caucus. We want the voters, the activists, to still get the sense that we're moving forward. You all can decide later on what happens to those delegates, but for our purposes, we want to make sure that they're delegates that are actually selected by the people as traditionally has been done for the past 43 years. So we're trying our best to keep things as normal as possible. We understand, we believe that the president's name will not be on the ballot. We don't know who will be filing on the ballot. As many of you know, New Hampshire has a history of having upwards to 50 or 60 names on the ballot of all sorts of very interesting characters. What we're determined is to not allow any of those people to claim that they've won the New Hampshire primary. And you have, I'm sure, read the stories that are your former colleague, former state party chair, and longtime DNC member Kathy Sullivan, along with a number of other party leaders, are going to conduct a write-in effort to ensure that the president receive the strong support. Not just, this isn't about the primary. We're looking towards November. We all know in 2000, if New Hampshire had been able to go for Al Gore, he would have been inaugurated as president. Those 4 votes, Florida never would have mattered. We are very bitter about that, and we are absolutely committed to making sure that New Hampshire, it has since 2000 always gone blue, that it will continue to go blue in November. So we want to make sure that Trump or whoever the Republican nominee is doesn't think that there is an avenue for them to win New Hampshire and dump extra money on top of us. We also have an open governor's race. As you've heard multiple times, we have a 1-seat minority in our House, and in our Senate is very close as well. We've got 2 battleground congressional seats. So we're focused on what's going to happen in November. And I know that you're focused on what's happening in the nominating process. My belief is that I believe strongly that Joe Biden and Kamala Harris will be renominated unanimously. And so my focus, as I said, is about winning that governor's race, winning the majorities, holding on to congressional seats, and making sure that New Hampshire's 4 electoral votes are never again cast on the Republican side. I don't know if the director or the senator have anything else. Any questions for us about any of the specifics of the plan?
Yes.
Yes, Mr. Chairman.
Chairman Buckley, in light of today's announcements regarding Iowa and the reaction of your Secretary of State, does that give you any possibility of giving us a clearer picture when you might be able to submit a plan that contains a date as we require?
As I said, he has up until probably the beginning of December. He's elected by the Republican legislature. He is a Republican. I served with him in the House. We were not friends. So I'm not able to know exactly what he has. Perhaps Senator Susie might have, in her role, had better insight on the situation.
Please.
I have not had a recent conversation, and certainly have not had a conversation since the announcement of Iowa's plan. I think the one indication I would take from the Secretary of State setting the filing period already is that a decision is imminent, but I could not at this very moment quantify the number of days by which he will make that decision. He does have until, as the chairman said, the beginning of December.
Any further discussion?
If I may ask one
Yes.
of staff, Veronica, if and when, and it's now sounding more like when, we have a plan with a date, how close would this plan be to conditional compliance?
We have a couple of issues to work through, but as I noted, Jack and the team did a really fantastic job working through the staff evaluation, so we were able to winnow quite a bit of it down. And I think we would just continue conversations about a couple of logistical pieces, but I think they did an excellent job with the plan.
So if I may further say. I think we previously, perhaps before we knew of the exact scheduling of this meeting, gave you a date of October 14 for submitting a revised plan. Am I correct about that?
That's correct.
So that is, we still have that pending. We could change it today. We could also extend it if we wanted to. So I'm just making sure that everybody on the committee realizes the options we have. So I'll turn it back to you.
Okay. Before we make that determination, I'll call on Joanne.
Thank you very much, Madam Co-Chair, Mr. Chair. I have a question for the staff. Given the, as you have stated, Veronica, the excellent job that the New Hampshire Democratic Party staff have done to address the concerns within the plan, could it be considered conditional compliance now?
I can't recommend that given the infringement of Rule 21C, which is the same reason Iowa's plan was initially considered non-compliant as well, and because of the significance of those three parts of 21. Yeah, I can't do that, but I really am looking forward to working through the rest of the plan and making sure it's in tip-top shape. So.
And I'd just like to make, just for everyone's reference, I don't think the Chairman Buckley, really emphasized enough how close New Hampshire is to becoming blue in this cycle. We have, under Chairman Buckley's leadership, have closed the gap significantly in the House. I think we're only 1 or 2 seats away. We have an extraordinary slate of candidates for the Senate, and we have a very robust primary for the governor's race with candidates that are extraordinarily qualified. So I know that in this moment, we're on the precipice, really, of turning New Hampshire blue, and I just wanted to acknowledge the party for that.
And I'll just mention in the House district where I have a vacation house in New Hampshire, there had not been a Democrat elected in about 25 years. They also had not done this, the local Democratic organization had not done a fundraiser in 25 years. They did one last year, and although it's a multi-member district, they elected one Democrat, just to reinforce what you're saying. I spoke at that fundraiser.
Blanco. Oh, I'm sorry. Artie. Oh, Artie and Tom. Okay, we got Artie, Tom.
Yes, thank you, Madam Chair. So I just wanted to make sure that I'm clear. I appreciate, Mr. Chairman, that you're trying to figure out what are all the options that we have here. One thing that I'm reading as I'm reading the bullet points is the 17 days before the primary to hold your preference primary, your pre-primary caucus. Why the 17 days? And I'm sure it has to do with like time to just do it all and process and count. But I wanted to ask because I'm trying to determine, so if your Secretary of State decides to choose January 15th as a date, then am I hearing that your pre-primary caucus would be December 30th? Like, I'm looking at what you've proposed, and I wanted a clarification.
So it was a few years ago that I realized or was informed that we were unusual in having our slating caucuses prior to our event, prior to the primary. For many years, I had thought that we were of the norm. Why we did that was to allow our candidates' excitement, the energy, the new people getting involved, There's always an informal competition between the candidates to find the most diverse and the largest number of candidates, and to who had the largest number of people turning out at these caucuses. We also are respectful of the candidates' staff, try to do GOTV, and so we try not to have it within that 2 week prior to the primary itself when they're involved and get out the vote. So it's during the excitement period, but it's not so close that it's impacting the campaigns themselves, and because they want all those supporters, the 300, 400 people that show up at these caucuses, to be out there knocking on doors or making phone calls, not sitting in an auditorium for 3 hours listening to, their neighbor saying why they should be a delegate. So what we do with those caucuses and why we have embraced these is that part of the registration form for the caucuses is, are you interested in being involved in your local committee? Are you interested in running for the legislature? Are you interested in being part of any of our caucuses? So we ask them a questionnaire, and so we literally gather several thousand new people each cycle of these people to show up at the caucuses. So the 17 days is something that we have determined arbitrarily, just so that it's prior to the primary, close enough so that everybody who's generally a supporter got to be involved, but not so close that it interferes with the campaigns.
David, then Mo.
Particularly in light of what we just did with Missouri, I guess I want to ask the following question for the record. If New Hampshire simply submitted its plan with the contingency that in the event that the public primary was in a date outside the window, that they would substitute a party-run primary with a date inside the window, could we then put it into conditional compliance? Since they, as I understand it from what we just did with Missouri, if the state government won't comply with the rules, the party can run a party-run process.
Yeah, I think that's what we have to determine. Yeah. Mo.
I'd like to go ahead and make a motion to accept the staff recommendation that we hold New Hampshire in non-compliance, and then move to the discussion.
There's a motion and second. The floor is open for additional discussion by the members.
So, yeah, Madam Chair, if I can.
Shoot.
So, everyone knows I love New Hampshire. I've done 2 tours of duty as a New Hampshire press secretary. That's why it makes me sad to see we're at a point now where New Hampshire could be found non-compliant moving forward. Today we saw 2 states who found themselves in positions where they felt like their hands were tied, find a way to untie their hands. We saw Missouri dealing with a Republican governor and a Republican legislature come up with a solution using a state party run process to get around that. And we saw Iowa, who had been telling us time and time again that their hands were tied, find an incredibly elegant solution to a difficult situation. And just as a side note, Scott, my man, like, what you guys did was fantastic, and I can't wait to hear your pitch in 2028. I think, I love the fact that we're going to continue to make this an ongoing conversation. But no state's hands are tied. We are seeing that time and time again, because the state doesn't choose the process by which we nominate our candidates. The party does. We've made that point repeatedly since we began this process. And I hope, truly, in my bones, because I know the New Hampshire Democratic Party is an incredibly strong Democratic Party. You guys have proven your mettle time and time again. I hope that if we do vote today to hold New Hampshire in non-compliance, and we're saying you've got 30 days to get there, that we can come up with an equally elegant solution in the next 30 days so that New Hampshire can do what you asked us to do, which is retain your long-standing tradition of being the second in the nation contest and doing it in a way that just elevates some other voices along the way. We can do that, and I hope that over the next 30 days we can get there.
Thank you, Mel. And I'd also like to say, in the spirit of what Veronica said, how well she's been working with the staff. I hope that over these next 30 days we can continue to do that, because I guess I'm the eternal optimist. I'm sure we will find a path. So with that, I'll ask for a vote on the motion to find the plan, unfortunately, in noncompliance. All in favor of the motion, say aye. Aye. Those opposed, say nay. It appears that the ayes have it. Jim?
Does appear that way.
Yep.
So, Mr. Martin has asked that the Minnesota plan, which we previously found in conditional compliance, return to this committee. Ken, would you like to offer some remarks?
Thank you, Mr. Chair. I believe the only item that is in, I guess, doubt or any contention right now is the provision around the delegation chair. I believe the rest of the provisions that were found in conditional compliance in our plan have now been satisfied. And so I would like to actually move that our plan be made in full compliance today, based on a really technical reading of our charter and bylaws, and the call, I should say. And so I don't want to get into the merits. We've already debated ad nauseum the merits of state party chairs serving as delegation chair. That's not really what I want this part to be about. I want to draw your attention to the certification requirements that are listed in the call. And this is really important because the certification requirements say that each delegation shall select one person to serve as a delegation chair. It does not say elect. It does not prescribe a method of election. It does not say that there has to be an election. It says the delegation should select. In fact, this committee has not said at any time, either in the rules that they've promulgated or in any statements prior to this, that there has to be an election for a delegation chair. In fact, the rule does not prescribe for that. The rule says there needs to be a selection. But let me just say this, that absent the prescription of a selection, then you go to Robert's rules. Because if our governing documents are silent, then we should obviously turn to other places that would provide guidance in this manner. And let me just read under Robert's Rule 1054, the motion to ratify. A ratification is in effect a selection and an election. Rule 1054 says the motion to ratify, also called approve or confirm, is an incidental main motion that is used to confirm or make valid an action already taken that cannot become valid until approved by the assembly. Until approved by the assembly. Secondly, I want to reference Rule 46.3, which is methods of nomination. Where absent any prescription on methods of nomination, the body always has the ability to nominate and determine their own rules for nomination. Under 46.3, it says, if no method of nominating has been specified in the bylaws, and if the assembly has adopted no rule on the subject, any member can make a motion prescribing the method of nomination. So I just want to come back to the original language that we proposed in our plan. It said, the delegation chair shall be the state party chair, which will be ratified by a quorum of the state's national convention delegates at a meeting to be held on June 2nd, 2024. There is nothing in that original language that is non-compliant with the call. There is nothing in the original language that is non-compliant with the call. Second, we have sent in additional language to try to comply with this committee around adding an additional line here, which says, the delegation chair shall be the state party chair, which will be ratified by a quorum of the state's national convention delegates at a meeting to be held on June 2nd, 2024. Alternatively, other national convention delegates may be nominated and an election held for the position of delegation chair. Now, that language has been submitted. And
So that has been submitted as an addition.
As an addition.
To your original.
Add an addition. I would argue we didn't even need to add that, but I wanted to be mindful of what Artie raised, which is sending a message to folks that there's no additional opportunity for nominations from the floor. This would assure in our plan that at any point people can make a nomination from the floor. But a ratification is in fact an election, and I want to make this point very clear. Again, this is, I didn't write the rules. All of us did. And there is nothing in the rules right now that we are violating. And I just want to come back to this because I want to be very clear. We can have the debate as we have about state chairs being the delegation chair. But as the rule is written, the Minnesota plan has not violated the call in any way, stretch, any way imaginable. And I would ask this committee to, at least on a technical matter, approve our plan in full compliance, because it's being held up right now on this matter, and we are we are in full compliance. And I'll leave it at that. Thank you.
Although you don't want this credit, I think your additional line, to my reading, sufficiently changes the meaning of the previous lines, because the previous lines by themselves, I understand what you're saying about a ratification being an election, but just if I'm a Minnesota delegate and I'm reading that, it sounds like a done deal. Now you've put in a line that says it's not a done deal, that there is an alternative method. To me, that's a significant clarification. Veronica, are there other issues with respect to moving to full compliance?
I haven't finished. I believe Aaron is doing Minnesota's review. I think we're still looking through. Oh, sorry. I think we're still looking through. The plan does look quite good. I think we're just doing some finalizing of it, so I can't say with certainty that it'll be in full compliance.
So, Frank?
I move that we refer the motion to staff to review and come back with it, or not come back with, but to consider.
So I think that's where we are right now. It's in conditional compliance, which means it's been referred to the staff that when they think the issues have been resolved, the co-chairs can move it to full compliance. So what I would appreciate is if anyone here on the committee differs with my reading of the new line, please say so. Artie.
Yes, and I want to say to Mr. Martin, thank you for adding this language. I would like to, and I appreciate that because we've had a robust discussion about this. But I would like to see the language. Like I appreciate you reading it and including that. I don't see it in my email yet. I'd like to see do we have copies to share with the committee so that we can actually see the language. That would be fantastic.
Yeah, and I'm sorry you didn't get a copy of that. I believe that was sent into the Party Affairs staff after the first review, right?
Yeah, an updated version of the plan should be in the Dropbox, but I can check that and bump that for you.
Can you put it on?
Yeah. So we're. All right. So I don't think we have to vote on this as an amendment because it's being submitted by the state party.
I was not offering it as an amendment because we submitted this. We heard Artie Blanco at the last meeting loud and clear, and I agreed with her, as I said at that time, that it is important for delegates at any point to understand that they have the option and the ability to nominate anyone from the floor. But that essentially what this does is it essentially just puts the state chair's name in automatically as one of those. If people then object and they don't want to ratify that single nomination, they could nominate anyone else from the floor. And that's how we always essentially do things.
This
But
makes clear that there can be other candidates.
Correct.
It's not the same as other states where you go into a meeting with nobody already considered chair. In many cases.
Well, that's correct. You would automatically have a nominee, and then the question is whether or not there would be additional nominees from the floor.
Right. All right. Do you want to make your motion? Yeah. Microphone. All right, David.
I think the concept that Ken is describing, that the chair is the nominee and others can be nominated, is fine. I don't like the language here, and I would not vote to put this into compliance. Because basically, if I'm a newcomer to the process, this says, okay, it's a done deal unless somebody somewhere decides that we're going to do some other deal, because all we're doing is ratifying a decision that's already been made. The whole concept of ratification should be taken out of this as far as I'm concerned, and just write it that the delegation chair is automatically nominated to be, excuse me, the state party chair is automatically nominated to be the state party chair, and
Delegation chair.
yeah, other nominations are permissible, you know, and just leave it at that. But the concept of ratification is a problem.
All right, so Ken, are you making a motion to move the plan to full compliance?
I would like to make a motion to move it into full compliance, if possible, with the existing language. Yes.
Is there a second for that? I do not hear a second for that. So that means it remains in conditional compliance for the moment. Right. Right. Frank?
Go back to staff and the co-chairs to resolve, or do we want to keep discussing
Is there
more?
a second for that? You can move it. Is there a second? And there is a second. Is there any further discussion of that motion? Since there was no other motion on the floor. Any discussion? All those in favor of Frank's motion to return the plan to staff for further discussion with the state party? All those in favor say aye. Opposed, no. The ayes have it. Okay, so that is how that is resolved at the moment. A number of you have asked me from time to time over the last couple of weeks, will there be another Rules and Bylaws meeting after this one? And the answer is obviously yes. To quote an old song, who knows where, who knows when, but there will be. We will meet again. So I think we have covered all of our intended ground for today. I think we did it very well and in pretty good humor, given what we were dealing with. Thank you all for keeping it on that level. And I look forward to seeing you again before long, and we will have our report tomorrow for the full meeting. Donna?
Wait. Go ahead, John, I'm sorry.
First of all, I want to say once again to you, Mr. Chairman, Madam Co-Chair, thank you for the outstanding leadership you provided over the last few years. I have lost count of how many meetings we've held, whether on Zoom, virtually, or in person across the country. But this has been a very productive process, and earlier Elaine talked about some of the institutionalists, and she mentioned Carol and the late wonderful former chair, Don Fowler. I consider myself an institutionalist, and I think many of you around this room have shown that you are institutionalists as well. So I want to just say to my colleagues on this committee how grateful I have been to have served with you throughout this process, which started soon after our last convention. Next year, as you all know, we will be holding our 2024 convention in the great city of Chicago, led by our chairwoman, Mignon Moore. But this convention will be held almost 60 years to the date of that historic convention in 1964, where President Lyndon Johnson was nominated to a full term. And, of course, Hubert Humphrey, a son of Minnesota, but a proud graduate of Louisiana State University, was nominated as vice president. I'm looking forward to hearing from our vice president in a few hours. But I also wanted to put on the record, it was a convention where the Mississippi Freedom Democratic Party came before the Credentials Committee to challenge the seating of that delegation. It was a summer of a lot of pain for many people in the South. They came before us just a few weeks after Cheney, Goodman, and Schwerner, two Jewish Americans and a black American, was murdered in Neshoba County, Mississippi. I mention that because, as you all know, today is Mrs. Hamer's birthday. She was born in 1972 in Montgomery County, Mississippi, and she was a guiding light for this party and this committee. And I just wanted us to close knowing that when we sit here every time, at least the 30-plus years I've sat here, we sit under her spirit, her guiding light, her courageousness, her tenacity for making this the party that we have become over the last 60 years. And so those Democrats who are here in this room and those who are listening to us know that this is your party. This is a party for all Americans, a party that will protect and defend democracy, freedom, and justice and equality for all people. So I just wanted you all to know how proud I am as an American, as a daughter born in the segregated Deep South, to serve with you, to learn from you, and to respect the work that you do. So thank you and safe travels back.
Thank you. But before we adjourn, thank you, Donna. As always, very, very eloquent. So, members, this brings us to the end of our agenda. But before we leave, we wanted to note that Chairman Harris and the Executive Committee requested that we ask a subset of members to review the Charter and bylaws to better understand what recourses state parties could seek regarding elected officials who switched their party designation shortly after the election. Now, to some of you, this will be breaking news that we're asking you to serve. Some of you have been already asked, so we're just hoping that for those who hear their names for the first time, we ask that you're willing to serve. We will be asking Ken Martin, Carol Fowler, Stuart Applebaum, Artie Blanco, Leah Daltrey, Frank Leone, David McDonald, and Tonya Williams to explore this issue and return with recommendations for this committee's consideration that we can share with the Executive Committee. You don't have to say yes today, but we hope you will serve. At the general session tomorrow, we will present our report, which will include today's recommendations on the Alabama challenges. Work still remains on delegate selection plan reviews, so we would ask you to hold, as Jim has already suggested, November 3rd, as well as Thursday, November 30th, and Friday, December 1st, for meetings in Washington. I'll repeat that. We'll ask you to hold November 3rd, Friday, yes, sir? No, it's actually the 7th. Yeah. It's, yeah. Is there anything? So,
November is very difficult.
yeah, right. Yeah. So we'll take all that in consideration. But right now, if you could just hold it, and then we'll get back to everyone. And I'll repeat that, November 3rd, as well as Thursday, November 30th, and Friday, December 1st for meetings in D.C. Finally, we wanted to notify you that we will be sending a plan from Puerto Rico again at our future meeting. While we conditionally approve Puerto Rico's plan, the state party has indicated they will need to move from a state-run primary to a party-run process due to funding issues. They have addressed this matter with the executive committee and voted to hold a party-run process on April 28th. They will vote on a new plan on November 2nd. So before we go, are there any additional questions?
As always, we'd like to thank our staff, our parliamentarian, the court reporter, the videographer, and everybody involved in this meeting.
Seeing no further questions, thank you again. Thank you, staff. Without objection, the meeting is adjourned.
I was supposed to meet with Governor, but we're at 1:45, so I'm going to.